Good morning, everyone watching our coverage of the Doomsday murder trial. It is April 21st, 2025. Fox 10 investigator Justin Lum here, joined by Special Projects executive producer George Obi. It is the day for closing arguments, really day 9 of this trial, but for the past couple of weeks, we have been here since jury selection concluded. And now today, this afternoon, at some point, we expect at 1 p.m., Pacific time, Mountain time here for us, Lori Vallow Daybell will present her closing arguments to this jury of 14, and then we will find out who the final 12 will be that decide her fate. At some point, this will all happen this afternoon. Then the question is, do we get a verdict tonight? Do we get it tomorrow morning? A lot of people have different opinions on that.
Well, the first would be, will she present a closing argument? She obviously didn't give a defense.
Nothing.
So I would suspect that she would have some comments at the end of her trial. But, with her, who knows? And then, how long does it take them to deliberate? And if the judge gets a sense that they are close, as we heard from Judge Mel last week, then he'll keep them into the late evening if he thinks they're close to reaching a decision.
It's up to them, right?
Yeah.
Like between the judge and the jury, that the judge has a lot of respect for, obviously doing their civil duty here. But maybe they'll want to have some dinner and kind of absorb everything they've taken in for the past. I mean, they had this nice Easter weekend, but there is not necessarily a rush. But it all depends on when they get the case. Okay, so we have got a live look at the Maricopa County Superior Courthouse. That's the South Tower. At one point this morning, you had a good-sized line of people from the public who have been sitting inside the courtroom watching everything take place. You've had the media there. We have a crew there as well. Lauren Clark with Fox 10 is there. And now everyone who's been in line and made it inside the courthouse now awaiting what's going to happen in the courtroom. At 10:30, court will be in session in real time. You all will get the delayed stream at 11 a.m. That's when the jurors will report back inside the courtroom and get the instructions. And Judge Mel told us how important these instructions are, even if it's just one charge: conspiracy to commit murder in the death of Charles Vallow, Lori's fourth husband. The instructions need to be understood correctly.
Yes, because all very important to the appeal process. Should Lori be found guilty and decide to appeal, very important they get this done. That the jury understands what they're deciding. In a case like this, when you have just one charge, one count, things get a little bit easier. But they'll come in, read those, and then like you said, we'll take an early lunch break and then come back for closing.
Yeah, and we know that Trina Kay is going to explain these instructions again and what they are being instructed to do, and be presenting her closing arguments as well. Trina Kay has basically zoomed through this trial with 19 witnesses, not 21 like we thought the state intended to call, but instead went with 19. A lot of evidence has been presented. A lot of people who follow the case believe that there should be more evidence presented, that there's so much meat to the story. But as we talked about, there are certain things that come from Charles Vallow that may not be admitted. He's dead. He's the victim in this case. There's body camera footage. There's body camera footage that's not been shown and that has been shown. Text messages revealed. An introduction to Chad Daybell, the Doomsday Prophet, who's on death row in Idaho. But also, they don't know much about him. They don't know the convictions that Lori has in Idaho. They don't know the whereabouts of JJ and Tylee. I mean, there is so much that is left out for good reason.
Well, and it's important to note that they're not supposed to know this. And if they do, it's not supposed to factor into their decision. We know that this is a world that we live in. People are going to know things or hear things. And as this jury is concerned, though, that they need to kind of keep that out of their decision. I do wonder, though, if there are, and I'm sure there are, of the 14 jurors, there are a number of them who probably don't fully grasp what Lori has already been convicted of in this entire saga, what they're going to think when they finally get done with this trial and they find out.
When they find out, and obviously it will be our goal to speak to these jurors, especially the ones that actually got to deliberate on this, the final 12, how they comprehended the evidence about light spirits and dark spirits and the whole Nephi story and I mean, there's so much, and then what their reaction was to Lori Vallow leaving the scene, not calling 911 for the shooting of Charles Vallow, going to Walgreens, going to Burger King. I mean, a normal human, you would think that they would be very shocked and maybe appalled at the reaction.
Yeah, I mean, we talked a lot about this, that if you're just a ordinary person just watching this all unfold in court, because like you said, we saw a lot, we didn't hear a lot because there was some stuff that was not admissible, but to hear from them at some point about what was going through their heads as they're watching this, and then of course they're hearing the testimony, yeah, I would imagine they'll have the same response that we all did, even from the very beginning when you and I first started covering this case in late 2019. I would imagine their reaction is going to be a lot of what we went through, and just kind of confused, shocked, dismay that you know that this could have played out the way it did. But hopefully they will. Hopefully, of the 14, and several of them will feel comfortable talking to us after the fact and at least explaining, you know, what was going on behind the scenes in court.
Yeah, their reaction to it all. We hadn't even seen the Walgreens video, the BK video at the time in 2019, 2020. We had watched the body camera footage of Lori Vallow and her smiling and not being distraught that Charles was even injured, even severely injured. Obviously, she knew he was dead already. And then later we find out, and I'm talking about later when she's indicted, that 911 had not been called by Alex Cox until like 47 minutes after the shooting. And then we find out that he's laying flat on his back for the second gunshot that ultimately killed him. So much has come out, but is it enough? What we've seen in this trial, is it enough for all 12 jurors to believe that she did beyond a reasonable doubt? It just takes one, right? It just takes one to be confused and to hold everyone up in jury deliberations.
Well, and they have to decide, like you said, reasonable doubt that she conspired with her brother to kill Charles. We have to keep in mind that this jury doesn't understand that she's going back to Idaho no matter what. She faces life in prison here, 25 to life, obviously. Irrelevant because, again, she's going to get shipped back. So if you think about the one person, what would be the one reason that they didn't do enough to prove that she conspired with her brother? We heard the jury ask questions. So if that one juror, if it is one juror that is undecided, are they the ones that were asking the questions? And if not, why not? Because there were certainly plenty of questions still to be asked, considering that Lori didn't put up a defense. So, you know, if we come to find out that 1, 2, or 3 jurors just couldn't convict her, then yeah, we're going to love to know why and what was left out. Because we have said this before, Trina Kay put up a pretty strong case, strong enough to where she decided, you know what, I got 2 more witnesses, I don't need them. And I'm just going to, you know, I'm going to rest my case and see what Lori has. And of course, we found out she didn't have anything.
And it only took Trina 7 days to finish. I mean, obviously, that also take into account that Lori did not object a lot, but there were 21 days screened. And we thought this could go like 5 weeks at least. And it went by in a week as far as witness testimony. Especially
when you have a defendant who is clearly, you know, not a lawyer, representing herself. We figured things would slow down a little bit, especially when it came to her witnesses. But again, you know, Lori once again surprises us and doesn't call any witnesses.
So I went on X today and I asked, when do we get a verdict in the Lori Vallow Daybell trial, tonight or tomorrow? I got about 120 votes from you all following me. 58.8% say it's going to happen tonight. Now, we know closing argument is going to take place at 1, but how long does that take? Could it take a couple of hours? And then maybe judge says, all right, jury, you've got the case now. It's 3 p.m. Yeah. It could happen.
It could. And I would think, you know, Judge Boreski has kind of kept this ship rolling.
Tight ship.
I would suspect that if he even has so much of a hint that they're close, why wouldn't you? I mean, they've already talked about the next case. We've got several more weeks before we have to get to that case. And if you believe Judge Mel, that case will never see the light of day. But no, I think Judge Boreski understands that it's important. The jury just had 4 days off, so I think they've had enough time just in that to kind of, you know, get their ducks in a row. And I guess we'll see closing arguments, whether Lori's closing arguments, or not, affect the jury's decision? Because I think that may hold a lot of weight. We'll ask the panel this too. Does it help a defendant if there are no closing arguments, whether it's, their defense attorney saying, we have nothing further, or does it hurt her to even say so much as, a couple paragraphs? Like, where is Lori's head, and does she think that her closing arguments are going to somehow impact their decision?
Well, she doesn't have to worry about being cross-examined in closing arguments because we still need to get her to officially rest the case in front of the jury.
Right.
Jury doesn't report until 11 a.m. What are we going to hear in the next half hour in these court proceedings, housekeeping or whatnot? I don't know what else is going to come up. The judge is probably going to ask her a third time, are you presenting any evidence? She has said twice now that she does not intend to, but she still needs to rest in front of the jury. So there's always that 1%. We don't know what is going to happen. And we'll show you guys the On the Record episode in a little bit, but want to give you a preview. We got a great panel on deck today. We've got 6 experts for the lunch recess. It's going to probably be a shorter recess for us, probably half hour or so, but we've got Judge Mel McDonald back on. We've got Susan Constantine, body language expert and jury consultant. We got Rachel Smith, special prosecutor for the Idaho trial that ended up getting Lori Vallow Daybell convicted in 2023. We got Taylor Larson, Charles Vallow's former attorney. Benjamin Taylor, a well-known criminal defense attorney here in Phoenix. And we got Tom Evans as well, the juror in the Idaho trial, who wrote a book, multiple books on the Chad Daybell, Lori Vallow saga. He ended up being an alternate juror, but he saw all of the evidence in that 2023 trial. And I believe, so we've got 6 people ready to go for this expert panel.
Tom will be great. Again, an insight. We've gotten an insight from the defense to the prosecution to the judge. Tom's going to be great giving us an insight on what's going through jurors' heads. Those cases, much more to deal with, much heavier topics, I think, because you're talking children. But it'll be interesting. And I think it's important for those of you watching on the stream this morning who might not be in Arizona, give you kind of a quick rundown of what we plan to do this afternoon. As soon as the jury reaches a verdict, we are on a 5-minute delay to show you show you what was read in court. We can, however, report on it live. So at some point, if you're watching the stream today and you're not local, you're going to see us take a quick second to interrupt the stream because we're going to go live on Fox 10 as soon as the jury reaches a verdict. We will then read that verdict live on air, but we will have to wait 5 minutes before we can show any of it. But you won't miss it. So if you hear us take a quick break, it's mainly because we know that there's a verdict been reached, and we're going to notify the folks on TV, and then we're going to go live on the air as it's being read.
Yeah, we're going to get some heads up when the verdict is in, so we'll be in our place, but we're going to be in 2 different time zones set 5 minutes apart, which is not bad because we've been doing 30 minutes for this whole trial, but you'll get to see that behind the scenes as I'm talking to our newscast. Going to be some adrenaline, definitely, as we're listening in real time to the verdict. But obviously you guys will be hearing it just 5 minutes later, and we'll be reacting with you all as well, and we'll have our panel ready to go. We'll have our panel, on standby for when we're waiting in jury deliberations. As long as this jury is in that courthouse deliberating tonight, we will be here. When we are told that they go home, then okay, that's a different story. But as long as they are deliberating, we will be here. All right, so let's get ready. We got just a few minutes left until court starts. But we had a good conversation with Judge Mel McDonald, who he had some technical difficulties last week, but he came back on, spoke to us for On the Record to talk about what he predicts will happen, even for the next trial, if there will be a next trial. I know you guys are all, assuming that we're going to have this Brandon Boudreaux case be brought out, and I think that's going to happen too for justice sake, for Lori Vallow Daybell to face some sort of accountability in court, even if she wants to represent herself. But it's going to be quick, and we're looking at June. So you guys stay with us. Let's watch On the Record from last Thursday. To rest or not to rest, Lori Vallow Daybell confirming to the judge this morning that she will not present any evidence to defend herself against the charge of murder conspiracy in the death of her 4th husband, Charles. Not one witness to call except herself. And at this point, the so-called Doomsday Mom will not testify. her first trial coming to an end as we get set for closing arguments. I'm Justin Lum, and we are on the record. And just like that, we are getting ready for closing arguments and what could be the last day of trial. What could be a verdict coming in regarding the fate of Lori Vallow Daybell. Obviously, we know that she's serving life in prison for her crimes in Idaho, murdering her two youngest kids, JJ Vallow and Tylee Ryan. But as far as her fate in this case for the murder conspiracy charge and the death of Charles Vallow, now on a Zoom right now, we have Mel McDonald, a former judge for the Maricopa County Superior Court, former prosecutor for the Maricopa County Attorney's Office, and a former U.S. Attorney in the District of Arizona. Now, Mel, we had some Zoom issues earlier, but so glad you could come on, and spontaneously, we're going to do this on the record episode right now, talking about what happened today. Jury instructions, very important. Talk about that for me, as the jury gets a break for the weekend, but they are going to be instructed on some fine details when they get the case after closings.
You know, one of the most important parts of the judicial process are the jury instructions. As a defense attorney, and I was a defense attorney for 37 years, as well as a prosecutor and judge, one of the things you strive to accomplish is in the record if there's any question on the jury instructions, you raise an objection. You challenge the instructions wherever you can, because one of the most common reversals of convictions comes in erroneous jury instructions. I noticed today that there were very few objections from Lori, which again comes back to the basic premise. She's representing herself. She doesn't understand the importance of her record. She doesn't understand that every time she has a possible objection and misses that objection, she waives the objection, and therefore it cannot result in any benefit to her on appeal.
All right, now we want to get everyone to listen to this because we're all waiting to see if Lori Vallow Daybell would actually change her mind, testify, present evidence. Judge Boreski asked her again today. Obviously, the jury needed to be there for her to rest. She said she would arrest yesterday. Today, she said again, she doesn't intend to testify or call any witnesses. Let's take a listen.
The state is present. The defense is present. The jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence.
Mel, how do you gauge Lori Vallow Daybell's demeanor? Is she being truthful? I mean, you have to be truthful, right, in front of a judge, but the way she says she does not intend to present anything, but we're still waiting for this jury to come into the courtroom and hear her say she rests.
Yeah, I would be surprised if she were to, on Monday, announce that she wants to put on evidence. The only witness that she could put on is her own testimony. I don't think that is likely. Before, I thought there was maybe a 51% chance that she would testify. But I think the point has been well raised that she doesn't like other people to be in a position of controlling her, and a prosecutor would have her on cross-examination for days because there's so many holes that she's created in the case. So my thought is that it'll probably go to the jury with closing arguments on Monday. But if there's one person out there that might boggle that machine, it would be her. I think it's part of her gamesmanship mode.
Good point. Now, Special Projects executive producer George Obie here as well. I mean, we did not predict to be sitting here on April 17th ready to get into closing arguments. That's for sure.
No, and I think a lot of us were hoping and maybe even expecting Lori to put up some sort of defense. So then I have to question, and Mel, you can help maybe answer this. What does she have to do, and how careful does she have to be in her closing arguments to where it doesn't come off as a defense? And you know, with her inexperience in all of this, you know, it almost feels like a slippery slope. What are some of the things that she is going to have to be careful of and not say during her closing arguments?
You see, my belief is that I don't think she's losing an ounce of sleep if she crosses the line in a closing argument. I thought when she announced at the beginning of the questioning of the jury or in her opening statement about not taking the witness stand, I think her thought is, and her plan would be to try, even if it's improper, to get her statement in, her defense in, without giving the state the right cross-examine, which would result in the prosecutor objecting, the judge ordering the jury to disregard the testimony. But I think, to me, that makes the most sense, her not taking the stand, giving the prosecutor the chance to cross-examine her, and then being able, through her argument to the jury, because she's not a lawyer, to try to put in testimonial type evidence as a part of her argument.
Good point, Mel. I'd like to put you in different shoes. First, I want you to, if you're a juror, and yesterday she cross-examined Nate Duncan, and she sort of schooled him on Nephi and the different books of Mormon, and you are a member of the LDS Church. Just how does that come across to the jury as she's basically telling Duncan how this religion, is supposed to be presented, and how he has used Nephi in that story to basically make her look like she gave an order to kill in this conspiracy?
From day one, I think the representation of herself has been a catastrophic disaster to her. Any chance, which was small, that she had of influencing the jury or getting sympathy, I think she shot out the window. You often hear about in trials, there's a smoking gun here or there. In this case, there's been at least 4 or 5 smoking guns. I think the chilling text messages, her demeanor on the day of the killing, not calling 911 when she's packing a phone, going around with her children shopping, going in and buying sandals at a store, stopping for food, not reporting. Every one of these things, coupled with the jury every day seeing her demeanor, seeing that she is bright and articulate, I think what that does is a person has a better chance of winning the lotto than she does of getting an acquittal. I think it'll be a quick verdict. If she doesn't play the game on Monday and claim that she now wants to become a witness in the case, I think they'll probably be out by Monday afternoon, and I would be shocked if a jury wasn't back by Monday evening or at the latest Tuesday.
Okay, because they will hear closing arguments at 1 o'clock, so you think that the jury probably gets the case about 2 hours after that 1 o'clock. They'll get the jury instructions already in the morning. So do you think that this deliberation could be an hour or so, hour and a half?
I think it could be that. It may go over to a second day, to a Tuesday. If the jury gets it Monday by 3 o'clock, I think there'd be a very good chance that there'd be a verdict before 5. And I can see this jury not wanting to come back on Tuesday and going through that. Mindful that there's been only 7 days of testimony. There's not a lot of witnesses, and the witnesses that were called had very specific points that they were brought in for. So there are probably 12 major points, I'm guessing, in the case, the different points that connect her to the conspiracy. There is zero sympathy I think for her and the hypocrisy of some of her testimony, some of her cross-examination, the gal that had gone out with Charles the night before, her trying to ridicule her when she is having an affair with Chad Daybell. There are so many factors in this case which I think has to have a powerful impact on this jury. And that's why I believe it's going to be a quick verdict.
Mel, for those that are unaware, from a judge's perspective, what will Boreski do? Will he get an indication from the foreman to find out where the jury is and whether or not he wants to keep them, say, past 4:30 or 5 on Monday? If there's any indication that they might be close, how does that work?
Typically, what happens is they operate on a work day. When I was a Superior Court judge, we would generally go till 5. I would send the bailiff to the jury room. It's almost 5. Do you want to recess for the day? The jury then makes the decision, informs the bailiff. We want to continue to deliberate. Typically, the bailiff will let the jurors know if you do stay, we can have food brought in, or you can go home for the day and return tomorrow. Oftentimes, if they're close to a decision, they're going to want to stay and complete the verdict so they don't have to come back the next day. I would suspect that's what would happen. The closing argument starting Monday morning, I see the prosecutor and Lori probably having their argument completed by 12:15 or 12:30. The state may have a short rebuttal in the afternoon. I don't know if they could put in the opening and the rebuttal in a 2-hour time frame, but then the jury's instructed and it goes to the jury. If the jury gets it by 2 o'clock or 2:30, I would not be at all surprised if a verdict is returned by 4:30 or 5. And probably at the latest, I don't see the jury going home if they're anyways close to a verdict.
Yeah, I was talking to Obi earlier about the 2023 Idaho trial. Jury got the case in the afternoon, but this was a heavy case, 6 weeks of testimony, probably 6 or 7 weeks, dozens of witnesses, and the jury basically had a dinner break, and then they went home, came back and deliberated fresh the next morning, and I think by noon or before noon, we had a verdict, and Lori Vallow Daybell was convicted on all counts, but there were like 7 charges. This is just one charge that they really have to go through instructions on, so it's a little bit different, but I think for this jury, everything is still so fresh to them, all of this evidence they've seen.
That's precisely the case, and I mean, I was a little bit shocked at how quickly the case went. I was anticipating it would be a couple of weeks, but quite frankly, Lori, again, representing herself, a lot of major witnesses, she doesn't have any questions. Those that she does question are fairly short questioning periods, and so the case has gone through rapidly. That's why I say the impact of the evidence with the multiple smoking guns, jurors in there's so many things that they can hang their hats on. And I've seen absolutely nothing. Probably the only argument I think that Lori has was, had there not been these post crimes, the shooting of the niece's shooting at the niece's husband, but especially the Idaho cases, when suddenly the focus is on it with Chad Daybell's wife passing away. I think that really put the heat on Chandler to really look at this. And the best part of the case for Lori is, had they not continued their crime spree, I think she may have had an opportunity or a chance of never being prosecuted for the murder of her husband.
What does she say in closing arguments? What is she going to do to get, one last shot to the jury to tell them that this was self-defense? How does she explain that one more time?
I don't know if it's possible to explain, other than what little bit that we've seen from her, that The evidence shows Cox had a wound on the back of his neck. She was faced in a situation where her husband, a former minor league player, comes at people with the bat. He has an altercation with the daughter or an argument with the daughter. I don't think there's much she can do, especially since she has no other evidence that was the only position put before the jury. And I think she'll try to suggest, some of the questioning when she suggested steroid use and trying to put Mr. Vallow in the worst light possible. Here he's going out the night before with a woman in the divorce hasn't even been filed. That's about all she has. And that's why I say her chances of anything of acquittal are the same odds as the lotto, and her chances of a hung jury are, I think, de minimis. I see it as a quick verdict.
And I don't want to look too far ahead, but obviously we know how unusual it is to have a defendant, high-profile defendant like this, represent themselves in one case. We know that it sounds like she's going to do the same in the next case, and these cases are coming almost back to back, a few week difference. They discussed it this morning. When you have dealt with cases like this, what are some of the things that have to be kept in mind when you have two cases as high profile as these are, this close together, and trying to find a jury? One of the challenges, obviously, is that they are, with the second trial, they're trying to get it done by the end of June. Is there anything that the public would need to know in trying to navigate making sure that both of these trials go on without any issues, without any chance of hurting a possible appeal?
I'm going to make a prediction here. I'm going to make a prediction that if she is convicted in this Vallow conspiracy to commit murder case, I'm going to predict that there's not going to be a second trial.
Wow.
And I'll tell you why I believe that is. She's already got life sentences in Idaho without the possibility of parole. There's a sound argument why the Vallow case goes forward this time. A person's life was taken, the cold, deliberate conspiracy to take his life. A conviction for this under the laws would be life with the possibility in 25 years. A judge, in doing the sentence, can have the sentence run consecutive. She's looking at 3 life sentences. Now, had the second case, had there been a killing, had he been severely injured with the bullet, I can see, because of the victim situation, that there would be sympathy. But from my days as United States Attorney, we would make calls all the time. There's no reason, in my view, to have the second case. She's never going to get out of prison again. It's going to be enormously expensive and time-consuming to have the second case. You don't have a victim that has been gunned down or dead. Fortunately, it was a close call. The information in that case helped the police in this case. I don't see any prosecutorial sense in going forward with the second case. So once they've got a conviction, I would be surprised if Rachel Mitchell and Trina Kay decide they're going to go forward with the second case. There's nothing more you can do to Lori Vallow than has already been done.
Yeah, I can see your point there. And people have said, hey, this is already a waste of taxpayer funds. And why is she doing this? It's a circus. It's a show. You see that, but you also see someone like the victim in the next case, Brandon Boudreaux, who survived this. And he wants, in his mind, he wants justice for himself. He's the only surviving person. And he will be on the stand and get his chance to really face her. And she'll ask him questions if she does indeed enter this trial representing herself once again. And that will be a sight to see. But for the families of these people, Charles, for Brandon, they just want to see her get convicted, at least face justice in all of these cases that have intertwined and created such a bizarre saga.
One of the things that Brandon has when and if and when she's convicted in this case, he would have an opportunity to address the court. The state can put on an aggravation hearing if they want to enhance the sentencing with the court. He would have the opportunity to speak. And yes, I can fully understand the feelings that are going through his mind. From a standpoint of people within the community, I think it would be a fascinating case, again, to watch. But from the practical standpoint, the effect on Lori Vallow, other than give her more time in front of the camera, so the jury can see her smiles and her actions, there's nothing to be gained by it other than the expense and pressure of the trial. She will have multiple conspiracy, conviction to commit murder, all of these other Idaho cases. She's never going to see the light of day. Mr. Boudreau will have an opportunity to address the court and make his pitch for the sentence in this case. So my thought would be for judicial economy and the fact that he wasn't hit with the bullet, that he has a chance to speak and know that evidence in this case also helped in the overall investigation. It doesn't make sense to me to go forward with this next case.
So if that were to happen, what is the likely scenario that they would work out a plea deal or just drop charges?
I don't think Lori's ever going to plead to anything. So the option would be move forward or drop charges. The choice would probably be a motion to dismiss. In the motion, the prosecutor could lay out a very compelling part of the motion, that she's been convicted of multiple heinous crimes in Idaho. She's been convicted of a conspiracy to commit murder in Arizona. She's looking at never getting out of prison for the remainder of her natural life. In the interest of justice and judicial economy, we move to dismiss this case. And that to me would make sense.
And then the final question is, does Lori Vallow Daybell file a response to that motion to dismiss? Let's not get too far ahead of ourselves, but wouldn't that be something? Because she does always have something to say. But I would assume that would be a win for her in her mind that, that got dropped. Obviously, this is all hypothetical, but we shall see. Mel, the judge, thank you so much for your time. I'm glad we got things figured out on the Zoom end, and we're going to see you Monday for closing arguments.
That'll be great. Good talking to both of you.
All right, there it is. So 10:30, we expect everyone in court. 11, jurors report, jury instructions, lunch, 1 p.m. closing arguments. This whole day is going to be for closings. And then at some point, the jury gets the case to 12, the final 12. We don't know who that will be. And we will be on verdict watch. It's going to be great.
It will be great. We'll obviously have it live for you here on the stream, whether we can air the verdict live or we're still on a 30-minute delay. But either way, we will be here like we have been the last 2 weeks. Yeah. And we will definitely have a lot to say one way or the other.
Yeah, it's going to be nonstop starting Monday morning. Yeah. So for all of you, subscribe, hit the bell. We'll see you on the record Monday. Good morning. If you're just joining us, Doomsday Murder Trial, Day 9, I should say, closing arguments set for today, Monday, April 21st, 2025. Fox 10 investigator Justin Lum here with George Obie, Special Projects EP, and we're about to get started in 5 minutes or so. We're looking at the state seal as we get ready for some court housekeeping before the jurors come in and report around 11 a.m. Our time. You guys will see that on a 30-minute delay, but they will be read jury instructions. But this is going to be interesting in the next few minutes as, parties get to discuss any issues they have with the jury instructions or any other issues regarding exhibits and things that happened during the trial. But again, we need Lori Vallow Daybell to officially rest her case in front of a jury.
Yeah, I mean, that's the first thing that I think we're all looking to hear from her this morning is, will she officially rest her case? She needs to do so in front of the jury when they report here in a few minutes. So yeah, we're waiting that, and then of course the procedural stuff of jury instructions, as we've talked about, very important. And then we'll take another break, and then come back for closing arguments, which I know we're all looking forward to because we fully expect Trina K to have quite a bit to say.
Yeah, according to the judge, depending on when they get the jury instructions and that is all finalized and gone over with the 14 jurors, then they'll get an hour. No matter what, they'll get that 1 hour lunch recess. So we'll be here ready to go with our panel of experts, and we expect around 1 p.m. Our time here, closing arguments will happen. And then after closing arguments are done, they will find out who the alternate jurors are. And it's going to be real easy because they're just going to pull two numbers out of a hat or out of a jar, whatever it's going to be. And we're going to find out who is not. And this jury is heavily outweighed by men right now. It's just 12 and 2 to two women that are still left on the jury. That's just what it is. So it'll be interesting to see who's left. We'll be watching for tweets from the courtroom. Lauren Clark also there. We'll be talking to her today to figure out who are the final 12.
Right. The final 12 will also get reaction from people. I mean, there are a lot of people who are not only following this case the last 2 weeks, either online or on the stream with us, but also in person. Just the amount of people that have showed up to get inside the courtroom each day. We're hearing a large group of people will actually be outside the courtroom every day watching and kind of following along. So a lot of interest and, again, a lot of reaction later this afternoon.
Yeah, we talked about this in the beginning or pre-trial, just how we haven't seen a trial in our area have this publicity in a long time.
Yes.
Is what I'm saying, since Jodi Arias. And maybe you can take us back to the timeline. There's some big cases, but to actually get that physical presence, and people to come from all walks of life.
Well, and you remember we had cameras inside the courtroom for Arias as well. I think this day and age that we live in with social media, and then of course with more kind of cameras in courtrooms these days, this has fueled a lot of it. But also, we can't forget that this is the case. This shooting set off the series of events that I think that we've all come accustomed to with the Lori Daybell saga, the Lori Vallow Daybell saga. So, for us, everything's just kind of coming full circle. We obviously covered the Idaho trials extensively. Not as much camera access in those trials, but
no, really,
no, and a small town like Boise, a small state like that, not a surprise.
No.
But even they're dealing with a high-profile case now.
So interesting how it's done where Boise's the capital of Idaho, but still, like, the way things are done is different. And when we did get camera access, it was the court's cameras. It was Zoom. But, like, for Jodi Arias, that was 2013. Was it earlier?
Yeah.
Just not to age you, but tell people what you were doing and how Twitter was starting off and really, like, blowing up and how it was covered. And how did it affect what we're doing today?
Well, I think that, social media had been around for several years, whether it was Facebook, Twitter. In fact, that was probably right near the height of Twitter, right before, things kind of took off. And there was obviously a lot of interest, maybe more so because you had such a high-profile female defendant. It's been my experience covering cases over the years that female defendants tend to get there's just more interest in it because I think there's an expectation that why would a woman do this, or why would she put herself in this position? Then you take Lori Vallow Daybell, where she's not only a female, she's not only been convicted in another trial in another state, but also there's that religious element, that this doomsday element that, I know that's the term that we kind of put out there, but it's a lifestyle that she chose, and I think that has been of interest to a lot of people, especially in this community.
Yeah.
We've had a few high profile cases. I remember when I first came to the market in 2005. I had to think about that. We had two high profile cases. We had the baseline killer, Mark Godot. And then right after that, we had the serial street shooters with Dale Hausner and Samuel Dietman. Two very high profile cases across the country, centered here in Phoenix. And then again, you have the Arias trial, which for us, similar to how we covered this trial, where we broke into coverage when the verdict was read. There was an absolute circus outside the courthouse that day and leading up to the verdict. And so, it's just the day and age that we're in now. Yeah. And we just, there's just so much interest in the judicial system, especially with a defendant such as Lori Vallow Daybell.
And we are getting a look at Lori Vallow Daybell right now, getting her notepad ready. She's got her counsel behind her as we're about to start and get on the record in a little bit. But still, jury not there at this time, but everyone's getting situated. You guys are getting a look at that, obviously on the 30-minute delay. But basically, whatever needs to be brought up and hashed out, this is the time. Confirmation on whether or not Lori Vallow Daybell intends to testify, present evidence. We know that this is like the third time she's been asked. She's been given some time to decide that, and looks like we're getting some audio here. Judge Boreski on the bench.
We're on the record, State of Arizona versus Lori Daybell.
We should address the audio. Will be a little choppy to begin with, but it will improve within the first couple of minutes.
Why don't I have the state announce? And the defendant?
Lori Daybell?
All right. We met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions, and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from next defendant.
Okay. All right. So, how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers randomly out of a container.
Okay. And when is that going to be done, and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
The state redacted out the beginning, the end discussions of hiring, have a figure saying or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes.
But it's just more or less what was played during testimony.
Correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
I don't know, it's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions, so either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into, to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That's exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes, Your Honor.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for, I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the state's closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20, is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right. We're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
All right. Well, that was interesting to say the least. Lori Vallow Daybell taking up a couple of issues with Judge Boreski, and mainly, first off, was talking about alternate jurors and how that's decided, and we talked about that. It's very simple and efficient. You just draw two names, or two numbers, I should say,
Yeah.
And they'll have 12. But then now she's back on this exhibit 286, I believe, on the interview done with her, conducted by Cassandra Inclan. And there's a certain portion, number of minutes that have been admitted as evidence, but she's asking why the full 55 minutes weren't admitted and how it was said or confirmed by Inclan that this was the full interview. And the judge explains time and again that there are portions that are redacted because of hearsay regarding Tylee Ryan. Like, I don't know what she's reaching for, grasping for straws here. She had a chance to address this even Thursday, right?
She did, and the judge, was clear in that Lori wanted to make sure the jury understood this was just a portion of the interview that they saw and heard, but ultimately the judge was like, well, you know, if the whole interview was to be included, then that should have been brought up during the trial. Whether it was 20 minutes, I think it was, that was shown of the almost hour-long interview. As we said, you know, this is, again, some last-ditch stuff. I don't know that ultimately she would want the whole thing played. Maybe she does, but I think at the end of the day, this is another case where do you really want to open that box?
Yeah.
And in the event, again, the judge said, look, this could have been brought up in cross. You could have asked Detective Inclin about it. You could have made the jury aware that the video that they're seeing is only a snippet of what was done. But again, all of this could have been brought up earlier and it wasn't.
This shows she's not an attorney.
Right.
She's acting as her own attorney. It's very clear that you're cutting out excerpts to use as evidence to show the jury. Plain, you're not showing the full 55 minutes. We all knew that.
Right.
And it was ruled on before trial that anything Tylee says or Alex says is hearsay.
Mm-hmm.
So if Lori in this interview is talking about what Tylee felt or Tylee said, that automatically wasn't going to be used by the prosecution.
Or she could have attempted to ask Detective Inclin, did I discuss this or this? Asked her, I think even the judge mentioned that, look, you could have in cross asked the detective about what was said or what you said in the meeting, and then maybe there could have been some dialogue on that. But there were a number of other instances where she didn't object. So this is just one of those cases where her inexperience, apparently her legal counsel didn't give her any heads up that she should have or could have objected during that as well.
Yeah, and so now we are just waiting for the jurors to report. They are making copies of the jury instructions, and then basically in some time when that's all ready, Judge Boreski will go over all of these instructions one by one, and then we'll talk about the count that she's charged with and accused of, conspiracy to commit first-degree murder. That's going to go on for some time. It is not very entertaining, but you will hear the instructions that the jurors will face, the 12 final jurors that will decide if Lori Vallow Daybell is guilty or not guilty. But we'll get a 1-hour recess for lunch after that is done. So we are getting there, guys.
We're getting there. Again, a packed house in court today. We already heard from Lauren Clark, who's in the courtroom. All the media is there, local and national. A lot of people we know. I think several of Lori's family members are going to be there. We know that Kay and Larry obviously following along as well. So it'll be interesting to see if we get to a point where the closing arguments happen. And like I said, I would not be shocked if Lori has, very little to say in closing arguments. But she's had 4 days to write it out. She's had 4 days to help or, get her legal counsel to help her put this out there. This will really be her only, comments made about the case.
Yeah.
Didn't take the stand. We heard opening arguments, very short and to the point. But we fully expect her to say something like, look, which was her kind of zinger question in a lot of her cross was, did you ever see me conspire with my brother to kill Charles? Something to that effect. And my guess is she'll end with that, is that no one in court ever saw her in person with their own eyes, see her conspire with her brother to kill Charles. I'm fully expecting that to be kind of the last line in her closing arguments.
And she will be told to confirm she's resting her case.
Yes, that'll be first.
As the first thing, and then we'll get into the instructions, and that has happened. So closing arguments is her final chance to, obviously she doesn't have to do anything, it's the state's burden, but it will be interesting to see what she says. She's obviously said in opening statements that, this is a family tragedy, and she said that self-defense is not a crime. And many times she said the evidence will show. The evidence will show. Every sentence started with the evidence will show. But, if you're the jury, I'm curious to know what they think about all the evidence that the state has brought, and yet she hasn't presented any evidence, which is ironic.
Well, the evidence also showed that she left the scene and was gone for quite some time before anybody called 911.
Yes.
I have a lot of questions for the jurors, because I want to know if they picked up on a lot of that. I thought it was pretty self-explanatory, those little nuances in the case. that she was driving around, or even the nuance that we've talked about, where she comes back to the scene and her demeanor is such that you would never know, or that she just witnessed her husband being shot and killed by her brother. I do want to know if the jury picked up on that and how that affected their decision.
So a lot of interest, like we've been talking about. Obviously, all the media is there, and we heard via X, Nate Eaton with East Idaho News reporting that they turned away about a couple dozen people from the public, I think, but basically a good amount of people who tried to line up this morning, but already, a packed gallery there obviously includes family members and probably law enforcement. And so definitely a lot of people watching, not just inside the courtroom, but here on the stream. We have nearly 2,500 of you watching the Lori Vallow Daybell murder conspiracy trial as we get ready for closing arguments. Let us know where you're watching from. Give us your questions and comments, and we might read your questions to the panel of experts that we have getting ready for this lunch recess. But right now, the very important stuff is what we are waiting to get out of the way and get done right and efficiently, so that we get to see get on this verdict watch. This is a trial that did not last as long as we thought. This is a trial where we thought, not necessarily that we didn't see fireworks or, very fascinating points and moments in the trial, because, yeah, it's just already unique to have someone represent themselves, especially Lori Vallow Daybell.
Well, we've had a number of people on our stream the last 2 weeks. Not one of them said this was a good idea for her to represent herself. That should tell you all you need to know about representing yourself. Yeah. Again, you have every right to do so, but it's obviously not recommended, and rightfully so, especially in a crime where you're charged with committing or conspiring to commit first-degree murder. So I cannot wait not only to hear the verdict, but the reasoning behind it. We'll obviously, hear from those who kind of followed this case the last 2 weeks, get their interpretation on it, including Rachel, who was involved in the Idaho cases. Her window or her insight into how Arizona did. I thought, you can speak to this. I thought Boise, they handled everything really well, considering the nature of both cases, Chad and Lori's case. I thought that, they had protocols in place that I don't think they'd ever had before when it came to no cameras, but court audio. And our efforts to get the audio from the courts each day, and we weren't the only ones. I thought they handled the media frenzy really well. And Arizona's done a great job, but again, they have more experience in doing so.
And they had to have a change of venue in Idaho. I mean, people forget that sometimes, where the crimes happen in Fremont County, between Fremont County and Madison County, small rural area. I mean, pretty much everyone in Rexburg, Salem, they knew what was going on. They'd driven by Chad Daybell's property. They saw all the media, saw the FBI, law enforcement presence, and they do not claim Lori Vallow Daybell as one of their own. She basically came in from Arizona out of nowhere, a stranger to the state who moved in, and within a couple of weeks murders her kids. And then Tammy Daybell is murdered. And so she is definitely, even though she's moved around a lot, was an Arizonan. She is Mormon from East Valley, Gilbert and Chandler. And she decided to move her kids and start a new life in Idaho right after the shooting of Charles Vallow. But back to the change of venue, it was just they were not going to take chances with trying to find a jury in both of those cases. So you move it to the biggest county, Ada County, Idaho. And yeah, it was handled well. And obviously everybody would like to see cameras in the courtroom and see it play out with transparency. But yeah, the way it was done was getting audio every day at the end, and you had probably 4 or 5 hours of audio. And then you'd have to find, what was said, go through what was said, and put stories together and reports. And here we are, fast forward 2 years later, and now we have, camera in the courtroom, just a 30-minute delay. So we've come a long way in this saga, in a case where everyone, or a lot of people know her name at least, and sort of know the headlines and what has been said and what she's been convicted of. But now it's up to these 12 final jurors, whoever they will be, to decide if she's guilty of this charge. And then we expect that the court, a spokesperson, will tell the jury that the media would want to talk to them about this right after. So there's a chance that quickly after, maybe not the same day, but there will be some jurors who come out and speak in a more press conference type setting, and we'll be able to hear what they thought about the case, their first reaction. That will be interesting.
Well, we know that the jury in both Idaho cases spoke after court. We have one on the panel later today, but it took a while, but they were open to speaking. And
that took time.
Yeah, and if you've ever listened to them, it's very emotional. They, I think, connected with the case. We should reiterate, obviously, especially with Lori's Idaho case, this involved both children, which any reasonable person would get emotional hearing some of what they heard and saw in court in Idaho. I don't imagine this case to be as emotional, but we think about all the testimony that was given in this trial the last 2 weeks. Lori's family members, Lori's brother, basically saying, yeah, I believe my other brother and my sister conspired to kill Charles. You have Kay Woodcock taking the stand. You have detectives who have been on this case and had already testified in the Idaho trial. So I thought the testimony from the state was very impactful, very powerful. And again, as we said, Trina Kay presented such a case that she didn't need to call her last two witnesses, and that she got her strongest witnesses on the stand. And I thought they delivered exactly what she wanted them to deliver to the jury.
Went heavy with law enforcement. You had almost 10 witnesses from Chandler Police Department. You didn't have as much like emotional testimony. Only 5 civilians, but Kay Woodcock was that emotional, powerful testimony to basically convey that she had been made the life insurance beneficiary for Charles Vallow. And Lori Vallow was not happy about it at all when she found out that she wasn't the beneficiary of $1 million. And her struggle to see J.J. Vallow again in her lifetime, to get J.J. Vallow to Charles Vallow's funeral after getting his cremated remains FedEx to her by Lori, and how she found out from Charles's sons that he had died, but they really didn't know how he had died. I mean, multiple family members having to go on the internet to find out that Alex Cox shot and killed Charles. I think we're still talking about it now. And so the jury knows this very fresh in their mind. We have a lot going on in our archives and our brain for this case, but the jury definitely remembers that. And the overwhelming evidence, I would say, not just on video, but going through those text messages on that final testimony with Nate Duncan between Chad Daybell and Lori Vallow, there's no doubt that there was an affair, right? And that there was a lot of talk about money. And so during these jury instructions, we're going to find out how they're written, the language, and what the judge says about what is a conspiracy, what is self-defense, what do you need to be involved in necessarily to be part of a conspiracy? Does it entail planning it? And it's probably not a full-on plan and, step by step. If you are knowledgeable and aware of what's going on, I mean, we're clear here that Lori Vallow is talking about Charles as a dark spirit. Yeah. We all agree.
Yes. Yeah, we all agree with that. And remember, we had Nancy Jo on early in this trial. She was one of the first witnesses to take the stand to describe Charles the night before he was shot and killed. If you go later in the testimony where, Lori, even in the cross of Nancy Jo, Lori tried to paint it as, oh, well, you're a woman who dates married men. Are you good with that? But then later we hear that Lori has already been dating and kind of, has already moved on from Charles. And for the prosecution to present that in that order, I think they wanted that part to stick with the jury clearly. I think
that was a hammer. That's a home run, because in opening statements, they do bring it up. Trina Kay brings up, that she did this to be with Chad Daybell. She wanted the money. She wanted to be with Chad Daybell. But they weren't hearing the stories yet about Lori and Chad. And so for Lori to cross-examine this witness who went on one date and basically criticize her for dating a married man, I think when the jury sees all the text evidence a week later, or whatever it was, I think it was about a week after Nancy Jo Hancock went on, I think they automatically lose trust in her as the defendant, because they're going to say, well, you went after this lady, but you were already in this relationship the whole time with Chad. we don't trust you. That's what I would assume, at least for some of the jurors.
Right. And again, they didn't hear all the other outside stuff after that and what she was doing and going off, getting married and all that stuff. I just, yeah, you're right. They hammered it home at the end and it stuck.
Oh,
all right, we are back on the record.
The jury is not present. We'll bring in the jury. All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions. Are we one? Oh, nope, we got it. Okay. The jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. One, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force. And two, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, one, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and two, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count one, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and two, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, one, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or two, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
All right, lunch recess for the jury, for the court, and at 12:45 they will report back into hear closing arguments in the Lori Vallow Daybell trial 1 of 2 in Arizona. Wow, I can't believe we're here.
We are here.
We are here.
The most important part of this entire 2-week trial has arrived, and the jury instructions, we went on for about 28 minutes, very detailed, but as we've heard from our panel previously, very important. The jury needed to take in a few factors, especially when you're talking about a conspiracy case, and the burden of proof obviously lies on the state.
A lot of important instructions for the jury, and we will also find out who will be the alternates and who will be the final 12 to deliberate. But let's not waste any time. We have got our expert panel. We have 6 that will be on the panel. We're waiting for one of them, Benjamin Taylor, will be joining us a little bit later in about 15 minutes or so. But I want to introduce you all to our esteemed panel of legal experts here, and every one of them have different insight and perspective. Now, Rachel Smith, special prosecutor in the Idaho trial against Lori Vallow Daybell. She's the founder of Smith Law and Consulting, focusing on assisting prosecutors nationwide as well as other civil matters. Her prosecution work includes appointments on sensitive and complex litigation. Taylor Larson with Ellsworth Family Law. He's been practicing here in Arizona since 2016. He was the former attorney for Charles Vallow. Charles Vallow, the victim in this case, who confided in Taylor as he was going through marital issues with Lori Vallow at the time, wanted her to get mental health and mental help for her mental health, I should say. Taylor Larson helped Charles file those divorce papers that were just, I mean, so fascinating to read now, years later, as he was asking for help and saying that there were major concerns with his then wife. And we have Susan Constantine, body language expert, jury consultant. She has covered so many trials. If you are being deceptive in any way, she will find out. Trust me. We have Tom Evans, juror number 18 in the Lori Vallow trial in Idaho. I mean, he didn't expect for his life to take such a turn, but he was sitting in that jury box, but he ended up being an alternate juror, even though he heard all the evidence, and he ended up writing 2 books on the Vallow Daybell saga, Money, Power, and Sex, the Lori Vallow trial, and Chad Daybell, the One, Mighty, and Strong. And finally, he's a retired Maricopa County Superior Court judge, a former prosecutor with the Maricopa County Attorney's Office, and former U.S. Attorney for the District of Arizona, spending decades in the courtroom. He is the judge, our judge, Mel McDonald. Thank you guys for joining us. We appreciate you. Closing arguments. I mean, you have to be a little bit hyped up for this. It is a serious matter, but we are going to see how Lori Vallow Daybell somehow, is this her testimony in some way? She decided not to present any evidence. Rachel, let's start with you. No surprise, she has declined now 3 times, but what do you expect to see as we get into closings in just a little bit?
Well, it all at this point kind of all comes down to the jury, right? And we're going to see both sides try to put forward their point of view to the jury. We're going to see how well jury selection turned out at this point. We also, we are going to see Lori take the time to try to sell what she believes the jury needs to hear. Lori's going to put forward her point of view, and I think this is where you're going to see her try to testify. Lori's going to have the last word if Lori can can get it in, and then we're going to see the prosecutor put forward and try to get out and help the jury understands very complex legal concepts, conspiracy, self-defense, some of the hardest legal stuff out there.
Now, in opening statements, Lori again and again said the evidence will show, the evidence will show, and the evidence will show that self-defense is not a crime. Now, she didn't present any evidence. Judge, what does the evidence show in this trial?
The evidence is compelling. If I were the prosecutor making the closing argument, I would lay out, starting from the beginning of their relationship, there are smoking guns after smoking guns in this case. The correspondence between her and Chad, the hypocrisy of some of the accusations and cross. I would make a point, if I was the prosecutor, to point out the things which Lori said the case would show that didn't. She opened that door. She said it will show this, it will show that. And she didn't show anything other than probably a lot of hypocrisy, and clearly showed that she was bright, intelligent, articulate. I think the case will go to the jury later this afternoon. I would be shocked if the jury is out beyond tomorrow.
Now, this has lasted for less than 10 days, really. Let's set the scene for you. We had dozens of people line up this morning to get in. People were turned away. We've got local media. We've got national media. We know the type of publicity and attention this case has garnered through all the trials. We've got a reporter going live right now outside the courthouse, and the jury's just getting a lunch right now, getting ready to make a huge decision. Tom, that brings us to you. You sat in that box and you listened to all of the evidence, and even though you weren't in that deliberation room, just what was it like for you to hear closing arguments in that trial in Idaho?
Yeah, it's hard to sit there. I hope that this jury stays awake actually after those jury instructions, and I think the closing arguments will be a little more exciting, and maybe they'll wake them back up.
Yeah, obviously the instructions are very, detailed and complex. But closing arguments, I mean, what stood out to you from the prosecution? Obviously, and Rachel was in that courtroom, but just what stood out to you in closing arguments, whether it was from the state or the defense in 2023?
I think that case, it was pretty cut and dry. There was a lot, just a compilation of evidence that added up to only one conclusion. So my mind was pretty well made up by that time, before we ever heard closing arguments.
Susan, what are you looking for in the body language, the demeanor from the so-called Doomsday Mom this afternoon?
So she's kept herself pretty well in check. I think we could all agree with that. A few times of being snarky, a little condescending, sarcastic at times, argumentative at times. But now the ball's back in her court, so no one is going to be asking her any questions. So she's going to be totally in control. What they're going to be looking for, in my personal opinion, is she showing any sort of remorse? I mean, her husband had died. He was killed. So is she going to be showing any genuine remorse whatsoever? The things that I would be looking for is her overall demeanor is so flat. I think that in itself speaks volumes, because it's not so much of what you see, it's the absence of things that we don't see. So the fact that she's not showing any sort of genuine concern, emotion, all of these are all the subjective part of it, right? They're subliminal messages. The other part of what I think they'll be looking for is how well she's able to articulate. She's very organized. She's very precise in a lot of ways, in her own way. What does that tell them about her personality and the fact that she could be a part of this conspiracy to do what she had done? Because this in itself takes a person that's very smart, very methodical, very organized in her thoughts. So in that respect, it may play against her, but who knows? All it takes is one juror, right? And I think we'll all agree it just takes one juror, a holdout, and here we go again.
And I think we can all agree that it would be shocking if she did show any emotion regarding Charles Vallow, if she said that she loved him. But we know that she has already said this is a self-defense claim, and that it's almost like Charles was the villain. She makes him seem to be in her case. So Taylor, I gotta ask you, waking up today, you've been down this road, this journey for 5 years. You were in that office when Charles came to you and said that he had problems with Lori. He told you that if anything happened to him, it would be Alex and Lori. And now here we are today for closing arguments. What is it like for you, full circle?
Yeah, it's, Justin, it's exciting to finally be at this point in this saga that's drawn on for, like you said, 5-6 years now. But it was in this office, this that I'm sitting in right now, where he foretold of how he was going to die, and that it was going to be, Lori and Alex who did it. So to finally be here, to finally, hopefully get some justice for Charles, it's a great moment, and I'm hopeful that, like the judge said earlier, it'll be a quick deliberation, and that we'll get to close this chapter here today, and it won't drag on till tomorrow. But even knowing that, if it does drag on to tomorrow, I don't think it'll be long for tomorrow. I think it'll be a shorter, a morning verdict. But remaining hopeful, and excited to see closing arguments, and excited to see if Lori's going to inject any of those emotions that you talked about. Will we see her put on the theater that she kind of put on at the opening? But I don't expect her to, because of the way that she's handled herself anytime she's talked about Charles in this trial.
Now, during instructions, the judge mentioned this statement that sort of went like, even if you are at the scene of the crime, it doesn't make you guilty of that crime or that conspiracy, trying to explain that we know she was inside the home when Charles was shot and killed. She left the scene. But Rachel, if you could take us into that conspiracy to commit first-degree murder charge in that language, you think something like that, the jury knows she went to Walgreens and Burger King, but it doesn't mean that she had to be the one to call 911 and do CPR on Charles, even though many would think you should do that for your husband.
You're absolutely right. Jury instructions of conspiracy can be very confusing. We will expect the prosecutor to kind of walk through language. The defense is going to focus on some language the judge used, which is called mere presence. Merely being present doesn't mean you're guilty of a crime. The prosecution is going to focus, when they discuss those instructions, on contribution to the idea, the planning, the agreement to have someone killed or to commit an act. So it's going to be about her contribution, her encouragement, her aiding of Alex before the act of murder, and then the consciousness of guilt she showed by her actions later. So those instructions were legal definitions that the jury will have to wade through, but we can expect, like you focused on, the defense is going to focus on merely being present when someone is shot doesn't make me guilty of conspiracy. And we're going to hear the prosecutor talk about those texts. It's all coming ahead to this week. Stay close to me. You'll be like Nephi. Those statements which show the planning, the intent, and her aiding and encouraging Alex in murdering Charles. So the prosecutor's job will be to take the legalese, all those legal instructions that courts spent years working on, and translate them into the evidence. And I think we're going to see that from Trina Kay. And she opened with the language she needed, which is stay close to me. It's coming to head this week.
Judge, what are you looking for in Trina Kay? As she's going to go an hour plus, and I assume that she's going to have some visuals to bring back up on the screen. You've been in her shoes.
Yeah, I think you start, when you look at the day of the event, there are facts that are absolutely overwhelming. Mind you, to have your husband shot in front of you, and you take your kids and go to Burger King or wherever they went, and then to buy sandals, you don't call the police, you don't do CPR. Any parent on the earth, if your child witnessed this, and Tylee was there, you would be traumatized. And yet you look at the videos of her at the scene from the body cam, smiling, indifferent. That is the starting point. And then you build the blocks before the relationship with Chad Daybell. I would have given $1,000 to have a video of her face when she found out the $1 million insurance wasn't coming in. These factors, piece upon piece, are going to be overwhelming. That's why, in my view, the instructions can be challenging. They can be cause some confusion, but in this case, no. There are too many chances that she can't escape. And interesting enough, I come back, the only emotion we ever saw from Lori was in the opening statement, with her daughter there, with this cold-blooded nature of this killing, no emotion. I suspect we'll see some more tears as part of the performance in the closing, but she cannot get away from the evidence. It will be a speedy verdict, and I'm convinced it will be a verdict of guilty.
Hey, Tom, you were in the courtroom in Idaho for sentencing as well. You wanted to be there to see Lori Vallow Daybell. She was sentenced to 3 life sentences for the murders of J.J. Tiley and conspiring in the murder of Tammy Daybell. Now, in her allocution, she does get religious and she does get emotional when she talks about her children, mainly Tylee Ryan, like Judge Mel mentioned. Do you think we could see some of that in her closing arguments, like she will use the name of Jesus Christ and, she's just a religious person? Is she going to testify something like this?
Yeah, it's very possible. I mean, this is her opportunity, right? She could try at this point to convince the jury that she is a translated being. I'm not sure if she's going to do that. So far, she's going to back off of that. But if she's ever going to do it, this is the time. So we'll see.
When you were listening to the evidence, what weighed out more heavily to you, religion or the money element?
In this case or in the first?
I would say the first case. Obviously similar as far as what the motives are being described and alleged by prosecutors.
I think for me personally, it was more, it was less the money. It was part that, but I think it was more just her crazy religious ideas. Yeah, I would have to say more of that.
Susan, I gotta ask you, and I'll ask the other prosecutors and Judge Mel as well, but as far as the jury, how much leeway they get in discussing their schedule? I think everybody is very curious of what we expect this evening, but by the time they get the case, it's probably going to be 3 p.m., 4 p.m. Pacific time. Who knows?
Well, the first thing they're going to do is they're going to select a juror foreperson. That's what they're going to do when they first get into deliberations. Oftentimes, they take a first ballot vote, to see how far they away from one another. So it could be very quick. We could see where they are as far as their baseline is concerned. Do we have a few people that are undecided? Sometimes, they set the rules. So there's no set of rules because they get to decide what the rules are and how they're going to do it. So how they end up in that procedure, the only way I can give you a description is through what I've seen in mock trials and focus groups, and they're all different. And sometimes they get really argumentative when they're in there, right? That some you've got like the Hatfields and the McCoys. Sometimes you have a division, but it really is based on that juror foreperson and their leadership qualities to be able to bring them together and to be able to make every single one of them be feeling that they're heard and they're validated. And then, of course, if they've got someone that is what I call a stronghold or someone that has a varying opinion, then they've got to go back into the evidence. And then what they do is they discuss it. But, it's really interesting, and I'm sure that all of here, my panel has seen it behind the scenes, and I've conducted focus groups and mock trials, and it's not a clear cut, this is how you do it, and we all do it the same way. Every single case has its own nuances, but I think that they're probably going to get back there and go, you guys, this is like the craziest thing I've ever heard. What do you think? I'm sure that there's going to be a release because they haven't been able to discuss this case at all. True. And to the point, whether it's the money or whether it has to do with the crazy story about the zombies and all of the kind of stuff. If I were a juror back there, I would be kind of stuck into this whole zombie thing saying this person is absolutely nuts. I think to the judge's point, I think that we're going to see a verdict come back very soon. I don't need, it may even happen. They may stay later. A lot of times when they get started, they want to just, if it's a first ballot vote, most are coming up with guilty or versus not guilty, that would determine whether they're going to go into the next day and go home. We don't know. That's the thing is about juries. We just don't know. We think we know. All we can do is do our best. But what happens behind closed doors has always been a mystery.
Yeah, to be a fly in that room, that will be something. And also to know the makeup of that jury. Every person is different, so we don't know exactly what we're going to get. But Rachel, take us back to 2023. The jury gets the case. And I remember they got like pizza for dinner in Boise, Idaho, and then they end up going home for the night. Just if you could, were you surprised that, do you think it was a quick verdict or did it take longer than you thought?
In my experience, I thought it was a quick verdict. I think there were some on the team who were depressed that it took as quote unquote long as it did, but I thought it was a quick verdict. They had multiple counts. They had weeks worth of evidence to think. And it doesn't surprise me when I hear Tom say going into closing argument, several of them had their mind made up. That most juries, if the prosecution has done their job going into closing arguments, most of them will have their mind made up one way or another. So no, back in 23, I thought it was a relatively quick verdict. You got to remember there were 3 sets of crimes they heard about and had to consider. They also had to consider the overall conspiracy spanning a year plus. So the amount of evidence that existed in Idaho and what was at stake was a lot greater than this jury has. This has been kept very narrow, very focused on Charles. If we don't have a verdict by tomorrow night, then there's something going on in that jury room that we're concerned about. I agree with the judge. The prosecution's done it. The evidence there, it's very clear. So we should have a quick verdict.
Hey, Taylor, I got to ask you because people watching have asked, why weren't you brought in as a witness for the state? I think your insight has always been, I've been talking to you since 2020, your insight into what Charles was going through. Do you think you're a lawyer too? Why would they not, give you a call?
Yeah, I've been curious about that, Justin, because I was waiting for someone to call from the prosecution. I was waiting for, even law enforcement to call me. Like we talked about a little bit last week, I don't know if it was the attorney-client privilege that kind of scared them away. But, like I said last week, most of the stuff was waived because Charles told me, if this happens to me, it was Alex and Lori and tell everybody, because I won't be here to tell it. And, it's interesting. I saw a lot of watchers are wondering why wasn't Charles's body cam brought in that we're seeing on the screen right now. And obviously hearsay kind of keeps that out. And so you have to bring in someone and, they could have brought in me to say, hey, this is what he told me 6 months ago. And he foretold of it, but that, I don't know if that would be kept out as well. But yeah, it's a question that I've always had on my mind throughout the saga of the last 5 or 6 years.
Well, we're glad to have you on as our witness, taking the stand for us every day on the panel, Taylor. All right, we've got Benjamin Taylor on the panel on deck, criminal defense attorney here in the Phoenix metro area. Benjamin, just your thoughts going into closing arguments, what you expect to see from either the state or Lori Vallow Daybell.
Lori Daybell has to hit a home run. She has to look at those jurors in their eyes and hopefully convince one or two. As we talked on the panel earlier, this is going to be a tough case. It's probably a quick verdict. However, if she can convince one juror, just one juror, she just needs one, right? So maybe she's been in this jury for the past couple of weeks. So he could probably key in, maybe one juror is nodding towards her. Maybe one juror is smiling towards her. Who knows what's going on in there? But she's probably going to key on that one juror or two jurors to hopefully convince them to go back in the jury room and say, hung jury, or I can't decide, I'm confused, and I can't, complete my decision here. And we'll see what's going to happen based upon the jurors' questions. The jurors' questions, if they have questions during this deliberation, is going to, we'll see what way they're leaning towards. But Lori Vallow better try to hit a home run by convincing one or two jurors to have sympathy for her or something in order to get a hung jury in this case.
Mm-hmm.
Or more like hit a grand slam. Have you done that? I'm assuming in the courtroom you build a chemistry with one of the jurors or couples. Maybe it's just a smile or not. I don't know. But just, Benjamin, is that what you're talking about? And then you zone in on them with your last chance to speak?
Yes. So every time Lori Daybell has been done cross-examination, the jurors are right there to her right of her. So she can look and see how the jurors are reacting to her questions, how they're reacting to the witnesses' statements. So if you see a juror smiling at you or nodding towards you, then you know maybe juror number 5 is on my side. Maybe juror number 8 is on my side. But if you see the jurors when they're like turning their head or going like this, or maybe even falling asleep. In some cases, when the evidence or they don't believe you, some jurors will just close their eyes and just like, you're done. And that happens in real life every day in trial. So Lori Daybell better have been paying attention for the past 2 weeks and looking at what jurors might be nodding at her, what jurors might be even having a glimpse of even liking her, in order to try to, like you said, Justin, hit this grand slam, because that's what she's going to need. She's going to need a grand slam in order to even have a chance of getting past this guilty verdict and trying to get a hung jury in this case.
Money Mel, you've got to have some stories from the courtroom. Looking at those jurors, you got to give us something. Is Benjamin speaking the truth here?
Let me pose this one question. Look at, if you're a juror and you're trying to see whether there's innocence here, looking at Lori Daybell, what is one fact that you can come up with that is favorable to her defense? In other words, we're talking about a jury hanging. It can't be her emotion at the day. It can't be that she's distraught. It can't be that she doesn't call 911. It can't be because the religious, he was possessed with demons. So when you look at the possible juror that might hang the case up, the problem with it, that is, there's nothing to hang it up. The only conceivable thing that helped her is the delay in getting the case prosecuted. And I think part of the problem was Kylie, on the day of the incident, apparently talked to the police. Lori apparently had her trained, and Alex did have a minor wound on his neck. But the fact of the matter is, when we talk about, well, yes, a jury can hang it, but to hang it, there's typically got to be something really significant to hang it on, and there's not. Her despair when the $1 million is going to somebody else, eliminating people left and right from her life that are a problem. I've got to believe the jury's going to wonder, where is Tylee as a witness in the case? She was in the house, but Lori didn't call her. Sure, she doesn't have to, but why? The reason I think the chances of a hung jury are remote is there's nothing, absolutely nothing, that's been brought out in this trial that's favorable to Lori Vallow.
Tom, when you were in the courtroom these past 2 weeks, did you see any, how would you say the jury reacted to a lot of this overwhelming evidence, specifically the religious stuff, the dark and light spirits?
Yeah, I don't think they reacted too well to all of that. But, so the way Chad and Lori operate is they throw out an impossible premise, right? And see who falls for it. That's their tactic. And then whoever falls for it becomes a follower of theirs. And so I'm guessing, I don't know what the number is, it's probably 1 in a million people would actually fall for that. And she's got a pool of 12. And one of those people has to be on that jury for her to be able to win this. And it's possible, it's just really unlikely.
Was there a witness that really stood out to you throughout this trial, out of the 90 witnesses, Tom?
I think just like in the trial in Idaho, it's not one witness or one thing that does it for you. It's an accumulation of all of it.
Yeah, that's Susan. What would you say about that for a juror's perspective?
Well, actually, can I kind of back up a little bit? Because I'd really like to speak on what we would be looking for in the juror that are either on board or off board. Do you mind if I speak to that?
Yeah, sure.
Okay, so some of the things that I look for when I'm in trial and I'm watching the jury is those areas of these little micro expressions. And I know we've heard about micro expressions in the past, but there are these very, very little subtle micro expressions that just kind of leak out. and they also go back to normal very, very quickly. And what that's doing is it's telling me subconsciously how they're actually feeling about a specific witness, parts of the evidence, how they feel about her. So what I'm looking for are areas of what, if you can see my face where my eyes all of a sudden become slightly narrowed, right? Or maybe my eyebrows lift and I'm surprised. Maybe I might even show a little micro expression of disgust and maybe a contempt, facial expression, eye rolling and contempt. So there's these little minor little subtleties that I look for that's telling me about emotions and cognitions. And then what I do is I record who's doing what when. And is there a pattern within specific jurors that are actually doing it? What are they hearing? Who's testifying? And how they're actually feeling about it at that moment? Because that's the stimulus, that's the probe. How are they immediately responding? So those are the kind of things that I would be looking for that would kind of give me a preempt on how that jury may be thinking, and how that would potentially end up as their vote at the end of the day. So also, I'd like to speak to about this. Maybe a holdout juror, as a judge spoke about. I sat all the way through the Casey Anthony trial. I covered that case from beginning to end. And there's also, I never thought for a million years that she was going to be found not guilty, right? But also, keep in mind, she is in front of that jury the whole time, speaking, and she's demonstrating, and her presence is known. There is something to be said about that familiarity, where a juror becomes immune to that person and seeing them as far as guilt or innocent. So I don't think that we should downplay that. I think the judge is correct, but there's also a phenomenon too, where I saw in the Casey Anthony trial, like how in the world could that jury possibly think that she was not guilty? And the reason behind it was because she was faced directly in front of that jury the entire time, and there was a sense of familiarity that happened there.
Interesting. Rachel, I want you to take us into your courtroom at the time in 2023. Did your team huddle up after certain days and notice that jurors were picking up and starting to understand this very complex case? Did you guys have notes on that, or was it just focused on the witnesses?
No, we did as a team, or more specifically, Rob Wood, who did the closing argument, myself and a couple of people, we sat down and said, okay, what did the jury seem to react to? Are we in danger of overdoing it? It became very clear to us that the jury had a visual and physical reaction to the pictures of both Tylee and JJ. And so that became a choice. Do we use those images again and walk through as much of the science about how they died as we had planned? And so there was some concerted discussions on what should be caught out of closing arguments, because you don't want to be perceived as overdoing it. And the jury's reaction had a role in how much Rob covered and how much the team asked Rob to cover in closing argument. So absolutely, we pay attention. We would look at the jurors to see how they were responding to certain evidence. I think sometimes that worries the jury, like, why are they looking at us? You're trying to get a gauge. How far do you go? What do you cut out and what do you key in on? And Rob shaped a lot of his arguments around how do we think the jury will see this, and what makes the most sense for helping a jury see and understand how and why a mother would participate in killing her children and killing her boyfriend's wife.
Yeah, it's a very emotionally heavy case, because I just remember being in that room for the graphic evidence that was shown. You could hear people crying. It was quiet, and it was just, you could feel that heaviness. It's something that you don't forget. This case is a little bit different. Obviously, still a man who's been shot and killed and gunned down after going to pick up his child, JJ Vallow. Rachel, I want to ask you this. Earlier today, Lori had issue with the video that was presented in court regarding her interview with Chandler PD, and she said that it wasn't the full interview, and confirmed that it was excerpts. Is that a common thing? The prosecution had to get rid of portions that included hearsay regarding Tylee Ryan, and she was picking at this for some time.
It is not unusual that the defendant will object to evidence being redacted and not redacted, chopped up, they'll sometimes say. And they will sometimes argue, well, that's not telling the whole story. That's not providing the whole narrative, or that it's editing the evidence. Had she had a defense attorney, those objections would have been raised before the exhibit was admitted. They would have been raised during her cross. And then perhaps most judges I know that if there's a debate between the parties about what comes in and what doesn't, the judge expects the parties to either work it out or you have a hearing on what else should be there. So the judge was very clear with Lori, look, any of these concerns that it's not the whole statement or it's not the whole story, the whole exhibit, your time is run, you're out of time to change it. That should have been brought up on cross. It's example 5001 of why Lori Vallow is her own worst enemy.
Yeah, Benjamin, how many times did you see opportunities for an objection where you're watching and you're literally saying it out loud as a lawyer?
I mean, tons of times when I was watching it, I wanted to say object. And she does have an advisory counsel there who's sitting next to her. I'm sure who's like, maybe nudging her arm a little bit to say object. But ultimately, Lori Daybell, she is her only, she's the main attorney. She's her only attorney. And she has to be able to articulate and write briefs and go in front of the judge and jury like any other licensed attorney in this nation. So unfortunately, that's what everybody on the panel has been saying. If she had an attorney, this case might be a little bit different today. Evidence being presented, cross-examination, but she's her own worst enemy by not having an attorney in this case.
Judge, if you were in the defense's shoes, how would you have been objecting throughout this trial? Where would you pick at?
One of the things that's important for your listeners to realize, the case that's being tried in front of this jury and this judge is only a small piece of what's really happening. There are appellate courts. There's the Supreme Court. There are federal courts. These cases often go through after that. That's why you have a court reporter there. That's why you make a record, because eventually that record will be reviewed. And as everybody on the panel has recognized, it is catastrophic when you represent yourself and points of error can come into the record, but you don't object. The law is clear that you thereby waive the ejection. So, for example, hypothetically, if there were parts of her interview that really should have been in or should have been objected to that could have constituted error, you make a record at the time, not only for this judge, but for the Court of Appeals, the Supreme Court, the federal court, sometimes all the way to the Supreme Court. That's why a person that represents themselves has a fool for a client. If you don't have a legal background, you don't recognize it, the advisory council cannot help her. And so the bottom line, all of these things work against her and eventually, I think, create a record that will be sustained not only with the conviction in this case, but by the appellate courts.
We have about 8 minutes left until the jury comes back into that courtroom. Taylor, what do you think has been the most damning evidence against Lori?
I'll go back to opening statements, and I'm sure we'll see it a little bit in closing statements, but the most damning thing for me has been that they planted the bat on the wrong side of Charles, that he was left-handed, not right-handed, and the gap in calling 911 after, and the second shot. Those are the three things that really stuck out to me and really kind of make me emotional, knowing that, Charles may have survived that first shot if it really clearly was self-defense, which we all know it was. But I think that those three things are going to really true for the jury.
Susan, you brought up the Casey Anthony trial and how the jury just they got to know her. They got to see her and feel her as far as what, she was like. Do you think that could be the case because Lori has been acting as her own attorney, talking to witnesses, talking to the judge, wearing civilian clothing?
I think it can go both ways. They're gonna, they're gonna either hate her, or they're gonna be some people say, she's got a lot of gall to be able to do that. But I think, it depends on how each person processes that information differently, and that's what we have to really understand about jurors. Everybody comes with their own backgrounds and their own beliefs and so forth, and then it's how they actually are processing that information. But for me, what I'm seeing is the fact that those jurors are saying, no, Kylie, not the son is not there. The visual impact. The visual impact of her smirking and smiling, her casual nature of after it happened, going to the store, getting the flip-flops, all of this is a visual presentation. 65% of jurors are visual. So when you think about how many people are visual, that means 7 people on the jury panel are going to be seeing these videos, and they're going to say something is really off. And I would assume that they would know that an innocent person does not act that way after their children's father was just murdered, especially right there in front of her.
Rachel, if you're Trina K, what are the visuals that you would want to show to the jury as you go through this hour of closing arguments?
The visuals are the things that Judge Mel has highlighted, Susan's highlighted. It's her conduct afterwards, her laughing, hi neighbor, after the death of her husband. You're going to present the picture and the angles and the trajectories of how Charles was shot, because that evidence is powerful evidence of premeditation. There's no reason to stand over somebody and shoot them a second time in a downward angle in self-defense. So you're going to see the visuals of Lori's attitude and demeanor, which reflects her desire for Charles to be dead. You're going to see the evidence that shows us it was premeditated murder, not self-defense. And then you're going to see the visuals from the text of the motive and the reason why she wanted Charles gone.
Yeah, I put this out on X this morning. When do we get a verdict in this trial, tonight or tomorrow? Majority, 56% people believe it's going to be tonight. Tom, what do you think?
It's hard to say. I think it could be, but I also think that the jurors are going to go through very carefully the instructions. That's why it went overnight in Lori's trial, is they wanted to be real thorough, go through, and the instructions were complicated, and that's just how long that took them. So I don't know how, this is a simpler case, obviously, so maybe it'll be a little quicker, but we'll see.
Okay, how about you, Benjamin? Benjamin? Susan, what do you think?
I think that they may go home today, get a good rest, come back tomorrow morning if they aren't already still ready to go and want to go home and get this thing over with. But I think tomorrow they may take a fresh start at it, and then we'll get the verdict either late tonight or tomorrow if they decide to stay late. So I don't think it'll go beyond tomorrow.
Taylor?
Yeah, I've been kind of worried because my schedule tomorrow, I have 2 court hearings tomorrow, but I was able to clear it. So I think that tomorrow morning that's my prediction.
So they'll get refreshed tonight, and that's what you're thinking. All right, how about you, Rachel?
I agree with the others. I think they'll, in my experience, jurors are very conscientious. If they've made up their mind early, they're going to want to make sure that they don't send the wrong message. They're going to make sure they show they're thorough and conscientious. They're going to go through those instructions. They may want to get a good night's sleep and face it tomorrow morning.
All right, Judge Mel?
I think it depends a lot on when they get the case. If they got the case at 3 or 3:30, I would suspect that they may want to stay late. Clearly, and I think from the standpoint in the juror's heart, we don't want to walk in and walk out in 10 or 15 minutes. We want to let the world know that we discussed it, that we deliberated it, that we went over the evidence. But there's nothing really that's going to create grave challenges. So I think if they get it by 3 o'clock or 3:15, there's a chance it could be tonight. But I think probably if it's late, I would agree probably tomorrow morning. If it goes beyond tomorrow, I would say there's a problem. But I can't conceive of a problem in this case.
Yeah, if it goes into tomorrow afternoon, yeah, I mean, we may be thinking what's going on in there. You all, thank you so much for being here on Closing Arguments Day. We appreciate you, and we'll see you in a little bit. Thank you so much to our panel.
Thank you.
Thank you.
Thanks, Justin.
That was quite the conversation there, and as long as these jurors are in that deliberation room, we will be here, and we will have our panel back on as we talk through the day after they get the case. It is going to be interesting.
It is. I want to go back to something Ben said that, we learned that the jury can ask questions, right? As Susan pointed out, this is the first time when they deliberate later this afternoon. That'll be the first time they have a chance to talk amongst each other. Again, great to be a fly on that wall. Then they'll have an opportunity to submit questions after closing arguments if they choose to. The judge will then answer those as best he can. I would wonder if that's a window into what they're thinking and how much we can take from their questions after closing arguments. They've asked a few questions throughout this trial, but I think if we were to hear more questions after closing arguments, I wonder if that gives us more of a window of how undecided are they?
Mm-hmm.
What do they want to clear up?
Yep.
And again, is that something that could leave the window open for one juror to say, look, I didn't think that the prosecution did enough to prove conspiracy, because that's what they're deciding. So we'll have to wait and see. I would think, depending on how late they get it, maybe they do want to spend the night and think about it and come back, as Rachel said, fresh in the morning and ready to either deliberate some more in the morning to make sure everybody's on the same page, or if the foreman feels like, look, we're all in agreement. I think that we could see that as well, because 2 weeks doesn't seem like an eternity to a lot of people. But when you're in a courtroom for whatever it is, 7-8 hours a day with 13 strangers, 14 strangers, I just, that could play heavily and be like, look, let's go home and sleep on it. Even if they think, yeah, we're all in agreement, but why don't we just come back first thing in the morning? So we'll have to wait and see. Closing arguments, though, are first up, and those will be interesting to hear.
We've been waiting for this. So in a minute or so, they will be getting into that courtroom. You guys will get to hear those closing arguments in about 30 minutes after that begins, and we'll be tracking it. But that was quite the conversation with our experts, and I'm telling you, we will be on all day long until the jurors go home. When we get official word that they're going home and recharging for the night, we'll call it. But stay here, subscribe, hit the bell. You know where to be. We are not turning this off anytime soon. 3,300 of you watching the Doomsday Murder Trial for closing arguments. We will see you in a little bit.
All right, we'll go on the record. State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. Go ahead and get the jury lined up, I guess. All right, the jury is now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, he sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention, to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later, on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother, and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case, and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming, and we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message. This one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad, 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? A gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is, in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car, and then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves, as Charles is laying dying or dead on the floor. 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she, again, calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's flight reservations from Charles's phone. not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant entirely handed over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages in Exhibit 230? It will be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad, the affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, Brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants, this is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. So what about those religious beliefs Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother Adam that their relationship had ended when she told him some things about her beliefs that he disagreed with. That she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more, though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs, and she said pretty much after that the defendant stopped talking to her. Now, how do we know she's being truthful?
Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him. Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say,
Did she tell
you as well as the other women who were at this meeting in February that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation.
Correct.
She was open about it.
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words. From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So, I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. The defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. It's where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day, and you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit stop before I go into the intersection? You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles. Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once?
Yes.
Can you describe for us sort of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says. but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so, as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, then we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th. Again, we have Melanie, who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is, from Detective Duncan and from Adam, that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense
that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that, in fact, we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles at center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees.
when he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back, before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. 1, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30. Pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around as he's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote. She is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him." And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. It's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th, in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, just because you don't have someone who says, I heard them say, we shall conspire, you can infer that from the conduct. The conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him, or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclen, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car? She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? to stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclin that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
In the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for, you know? He's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened? How did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and...
He comes back in, I wouldn't give him his phone. He was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there, and he was screaming at me. And I was kind of walking towards around the house with it, so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. He got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut, that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But what we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
Field with your brother.
Yeah. What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Right, left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
And what happened?
Then they got up from that, and my brother had stepped back, I guess, and then Charles was coming with me to that and yelling at me to give him his phone still, because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, backwards, almost in one arm.
Like he was swinging it backwards? He would have done
he would have swung it backwards at me, not frontwards.
Okay.
So Lori Vallow tells Detective Enclan that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down? Out? Somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence.
So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen, down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Coons told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun, within Charles 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and he doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it. Someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it. No scratches to it. No dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see
that she's wearing the flip-flops when she comes back to the scene? What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who've come here and talked to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day, where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband, who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence, and you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. It's Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have 1 kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We've talked about a few things, but
One of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. Oops. If this will play. When she was questioning Detective Enclan, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
You live here though, not in Santana, this is your home?
Right,
Gotcha.
right.
Okay.
We just moved in.
Gotcha. How long have you guys lived here?
I'm sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors don't know us very well.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to.
This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, the projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand, and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes. All right, please be seated. The jury is present. The defendant can proceed with her closing argument.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction, under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms, where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, My police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews or let you listen to the 911 call.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inklin to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough was not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. Testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only three witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial, elected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was, self-defense, and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
All right. That's sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
All right, the state does have the burden, so they have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him. This defendant. The state, of course, has the burden. And that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14.
Five.
Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing the verdict to anyone, so help you God? I do. Thank you.
Izzy, drop those off. Undrop those off.
All rise for the jury.
The jury's no longer present in the courtroom. I've passed out proposed aggravation phase jury instructions. In the event that there is a verdict of guilt, the state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
There's a spelling mistake on page 3. That's as a 3 in it.
Got it. All right, we'll be at recess until we hear from the jury.
All right.
And there you have it. The jury officially takes the case against Lori Vallow Daybell. Now we're going to catch you guys up here. Fox 10 investigator Justin Lum, joined by Special Projects executive producer George Obie. We know that it took the jury about 10 to 12 minutes to deliberate or whatnot before they ultimately decided to go home for the night. So verdict watch is on, but they're going to come back tomorrow morning at 10:30 to really start off deliberations. They have taken in a lot of evidence. That was a long closing argument by Trina Kay, about 20 minutes for Lori Vallow Daybell, but really Trina Kay dominated that closing arguments portion. We're going to get to our expert panel, but yes, we're not sitting here on pins and needles. We know the jury's basically heading to the sideline right now to recuperate and get back at it tomorrow.
Yeah, had a 4-day break, came back. Trina talked for a little under 2 hours, gave her closing arguments, and then had a rebuttal to Lori's closing as well. But she went through meticulously the timeline that she had kind of already laid out in her case in the last 2 weeks. So interesting that she was so specific. She mentioned the 12 minutes. She mentioned that almost a dozen times, kind of hammering home this idea that the timeline from the shooting to when 911 was called, everything that kind of happened into that kind of alluded to premeditation, the conspiracy part. So yeah, they took in a lot. I don't blame them for wanting to go home and sit on it. As we talked about in our panel earlier, it's the first time the jury has had an opportunity to talk amongst themselves about this case.
Mhm.
So I wonder if that conversation was in like, look, we all have a lot to say here. I'm sure they don't want to be there all night. So what better way than to come back in the morning, fresh face, deliberate. And I would get the sense that they would have a decision by the end of the day tomorrow now.
And they have a 4-person now. Let's get right to our panel, okay? Rachel Smith, special prosecutor in the Idaho case against Lori Vallow Daybell. We have Benjamin Taylor, criminal defense attorney. We have Taylor Larson, Charles Vallow's former attorney, and Judge Mel McDonald. Rachel, I know you only have 15 minutes to give us, and we appreciate that. Your thoughts on how Trina did?
Trina did a solid prosecutor close, very traditional, very detailed, walked them meticulously through that timeline, gave them a summary of pretty much all the evidence that they will need or have to hear, and explained the law to them. So she gave them a lot to think about. She put it in context, and it was a very clear, detailed, concise outline of what Lori Vallow did and why she needs to be held accountable.
I definitely think that Trina hammered it home. I mean, she really went through the timeline. She even showed testimony clips. Rachel, I mean, maybe that's not uncommon, but I thought it was interesting that she brought the witnesses back with little sound bites throughout.
Yeah, there's different studies out there, but the most recent numbers I've seen is that most people retain better when they see something. It's 80% of the population are visual learners. So including visual items in her closing argument at key points increases the likelihood that will be the takeaway of that jury. So I think including visual is extremely important, and including the key testimony of the victims of the witnesses in the witnesses' own words, rather than her just reading it or saying it, I thought was an important touch to remind them of who people are, what they look like, and exactly what they said.
And based on my original notes, the 2 jurors that are now made alternates, I believe, are 2 of the men. So it looks like, and we have 10 men and 2 women on the jury, the final jury of 12, and they have chosen a 4-person, obviously, and they've decided to call it for the night. Judge Mel, what do you think about that?
I'm not surprised. They've had a long day today. It went beyond 3 o'clock, and it makes sense for them to adjourn the case for the day. I thought it was a very fascinating argument. I think Lori did bring up the one point that she can, that the case actually went up to 6 years before everything honed in. That is probably her only argument. What mystified me in her argument is you see the Lori Vallow there that seems intelligent, bright, and then you hear this Lori Vallow from the evidence for all of these days with these evil spirits and Moroni and lies about life insurance and that. It's like there's 2 different people. And while her argument I thought was well organized, every time she tried to interject testimony in that she didn't put on in her own defense, I think it was cut off. I look for a verdict before the end of the day tomorrow. I can't conceive of a jury finding her not guilty. And quite honestly, I think the likelihood of a hung jury after all of the evidence and the compelling evidence is very small.
Judge Mel, you mentioned that it was like she was 2 different people. Fun fact for everyone, she is a Gemini. We'll say that. Benjamin Taylor, she did bring up Tylee Ryan and Alex Cox, and there were multiple objections sustained because what they say or anything regarding those 2 is hearsay. And so it became very tense in the courtroom, and you knew Trina was waiting to get back on rebuttal. What did you think of that interaction? What do you think of Lori's argument in closings?
I mean, Lori was trying to bring in evidence that wasn't presented in trial. So that's why you saw the prosecutor get up and object multiple times, because you can't bring in evidence or testify to evidence that wasn't presented. Earlier today, I said that Lori Vallow had to hit a home run. I think she might have struck out, unfortunately, in this closing argument. It wasn't the best, I would say, unless those some of the jurors that we saw. We can't see the jury, of course, but unless she saw some jurors in there that she keyed on and she talked to, that might help her. I think the one good thing is they're going home for the day. I think if they really wanted to convict her right now, they would have stayed. It's still early in the day. They still have another, 2 hours to deliberate. They really wanted to. So the fact that they went home, I am kind of curious of why did they go home and not get to work today if they really wanted to convict her. So there must be somebody in there that wants to hear more evidence in order for them to say, let's get a good night's sleep and come back in the morning to talk.
Interesting point. And she did tell them that she encourages them to watch the full interview done by Chandler PD, since they got to see it in snippets. Taylor, how do you feel about the way closing arguments went today?
I think they went great. I think Trina did a great job of kind of walking them through the timeline, walking them through the motive, replaying those bits of testimony, because, that I think showing the actual testimony instead of just talking about it adds credibility, to those witnesses. And so, I appreciated Trina also brought in some metaphors that the jury members can, really relate to. And some of them may relate to it driving to court today or driving home today when they come to an intersection. So, I think that her strategy, her tactics were great. And, and then the rebuttal, I think was even better. She really drove home the we and that text message, and that it came from Lori. And that really is what I think is going to ultimately convict Lori.
Rachel, do you think maybe Trina went a bit long? I mean, I know she had a lot to cover, but almost 2 hours, and then the rebuttal, and then, the jury says, you know what, we're going to call it for the day after 10 minutes or so.
Hindsight's 2020. When you're standing up there, you have an outline, you have a plan. The timing is never what you think it's going to be. I don't think she set out to go for 2 hours, but she had a timeline and had things she needed to hit. When you're standing up there and looking at the jurors, sometimes you'll pause because you want to make sure they're following you. Trina made eye contact. And so it always takes longer than you think you will. But what she did do was get through everything she needed to get through. She got through that timeline, which is extremely important. She used Lori's own words against her, which is extremely important. And she tied Lori and Alex together as the we who eliminated Charles Vallow. So she did what she needed to do. She read the jury in. No one else standing there could have told her when to cut it off or not. She had a plan. She stuck to it. She followed through.
And me and you talked about this before today, the PowerPoint presentation and how that would come into play. She brought up money motives. She brought up the affair with Chad Daybell. She brought up Adam Cox, Lori's brother, talking about these, quote, twisted religious beliefs. And at the end, she finishes and says, hold her accountable, find her guilty for conspiracy to commit murder. But she said, this is about money and Chad Daybell. This sounds just like deja vu from the Idaho trial. Do you feel like that sort of laid the groundwork? This is sort of a mini case from that Idaho trial?
I think it is very much a mini case, not of the Idaho trial, but of the evidence. The evidence in the witness information, the motive, the planning, the use of religion as a manipulation and power tool transcends trials. It's what they did. And so the prosecutor and prosecution in both cases let Lori's own words and actions speak. It just happened to be the same thing both places.
And I got to ask you one more before you have to leave us. I wish you could stay on longer. But as far as the shoes, why was that so important for Trina to bring that up, that Lori had talked about running out barefoot? And she takes us back to Walgreens and shows everyone the obvious.
Right. the thing is, there may have been efforts for Lori to try to make it look like an accident, make it look spontaneous. And so Trina connecting dots on things that to make sure the jury sees the evidence right in the right way is extremely important. And that is one example. She's anticipating a potential defense argument, and she's taking the time to show the jury why that argument would not be true.
Oh. Rachel Smith, thank you so much. We'll see you soon. Taylor, I want to know your thoughts about that, seeing that confirmation about the footwear on Lori that day of July 11th.
Yeah, I mean, that when we first saw that played out here at the trial the first time, we hadn't seen the Walgreens footage, and everyone pointed out that she was wearing shoes. And my thought was, where did those shoes go? And did they possibly contain evidence on them and that's why she ditched them? I kind of understand that maybe she's trying to make it look like it was spontaneous and she ran out of the house with Tylee without shoes on. But, I don't know if that was, part of the plan that Lori had, or if her and Alex were smart enough to think of this. But, because it's interesting, like Judge Mell has said throughout the time of this trial, Lori comes across very articulate, very bright when she's speaking in court in front of the jury, but there's so many missteps in the plan and the overall scheme, not just with this trial, but with everything that happened in Idaho with the kids and with Tammy. So it's like she's a smart, dumb person. And so I think that I don't know if I can give her enough credit to come up with this spontaneous plan to go and get sandals. I think it was more that there may have been some blood on the shoes or something that she was, getting rid of.
And Judge, we're looking at that video from Walgreens just now. And Trina K also brought up the demeanor. You have brought that up again throughout analysis and coverage of this trial, that Lori didn't shed a tear. Lori didn't do anything or have any sort of response to Charles Vallow dying inside that home. Do you think the jury just needs to recharge before they get in tomorrow and weigh all of this out?
Yeah, I think they do need to recharge. I think they're the strong part, I think, of her argument, and I didn't think at all it was too long. She had all of those witnesses, and it's important for the jury to understand each of the pieces of those witnesses. I think the evidence of the day of the crime, all of the evidence leading up, the planning, the Moroni, the evil spirits, but then leading up to the language and the text messages, and then the evidence of the day, I can't walk away. And this was the thing that struck me, how cold-blooded Lori was. Indifferent. I mean, you've got a daughter that has seen somebody shot to death, or at least is shot to death in the house. Supposedly, you've got a brother that's been hit in the head with a baseball bat, and she's out there as completely indifferent. And I think putting these pieces together and hammering that point, that to me from day one was chilling. This woman does not have a conscience. I think that maybe she's used her weird religious beliefs to nullify it. Maybe she, in her twisted mind, thinks that, gee, I really am perfect. I don't need to repent from sin. But every part of that plane and scene of this case shows somebody that was cold-blooded, that was heartless, that was conniving, and all the words that she can say in her closing about her husband, this evidence, her text messages, all of these witnesses, the way the body was positioned, the second shot on the floor, all of these things were vital to show that she was part of a cold-blooded conspiracy. She's going to be convicted tomorrow.
Benjamin, I want to know your take on the religious aspect. It seemed like Lori tried to flip that over, the whole Nephi story and the directive to kill that was being laid out, and she basically waters that down, or tries to, for the jury. And we were talking, and you said she should, go for a sympathetic juror, but she was not emotional at all.
No, she wasn't that emotional, and I think she should have, kind of like honed it down really and even cry. I mean, you had to pull out all strings here. And she should have cried. I know she mentioned the religion, maybe used the religion, thou shalt not kill. However, this was a total self-defense and just did whatever she could. I felt like she was talking up there, but she didn't really, go for it and try to really, really get in the heads of the jurors. So, but like I said earlier, she's still alive right now because the jurors are going home. And if they really wanted to convict her, they would have convicted her right there because the jurors, they're tired. They've been here for, this is the third week of this trial. So the jurors are ready to be done with this and go home. But for them to say, well, time out, everybody, let's go home right now and regroup to tomorrow, that's what I'm curious about. But I wanted Lori to really kind of go after it if she is a defense attorney. And I'm sure her advisory counsel probably counseled her a little bit, but because she didn't present evidence in court and Trina K, the prosecutor, was able to object all the time, she really didn't have much to argue. The only thing she could really argue is reasonable doubt, meaning that it's the state's burden to prove beyond a reasonable doubt. It's not my burden, it's their burden. So that's what she was kind of arguing, burden, reasonable doubt, and hoping that somebody has doubt on that jury.
And there were multiple objections where prosecutor Trina K said she was basically testifying as she was asking the jury, why is the state trying to blame me for this family tragedy? Why are they trying to make this family tragedy a conspiracy to commit murder conviction? Why are you not hearing all 3 interviews from the family when we know the ruling on Tylee Ryan and Alex Cox in hearsay? And then she really points at Chandler PD and says this is their issue. They had a problem investigating this entire case, and now here we are 5 years later, and they're trying to convict me for a crime I did not commit. That seemed to be the narrative, and I just wonder, Judge, I'm going to go back to you. I know you said this is going to be a quick conviction, but maybe there is there one juror that could listen to that and say, hey, you know what? Chandler PD didn't test for this, test for that. Maybe they are playing devil's advocate in their mind. Just want to know your thoughts on that, Judge.
Let me ask you a rhetorical question. Of all of the overwhelming evidence, the text messages, the meetings with people at the girls' retreat, all of this language in her closing argument, Lori did not even address those issues. She doesn't address the dark spirits, all of the emails, the relationship with Chad. There's absolutely nothing that she addressed. So when you look at the state's case for the 6 days, there was the forensic evidence, the medical examiner's evidence, the detective's evidence, the text messages, the cold and callous behavior on the day of the murder. All of these things are not addressed. She gets up and reads jury instructions, trying to suggest reasonable doubt. She talks, the one thing she does say is, yeah, my husband and I had marital problems. That on a 1 to 100, that's about a 1 of what was really going on. The emails, the interception and stuff like that. The bottom line, she didn't have any evidence to put on. She didn't rebut the evidence of the state. And I think even more so than the beginning of the case, I thought Trina put together all of the pieces of evidence in the case that needed to put in the forensics, the emails, the testimonial witness, her own family members talking about the conspiracy. I can't conceive of even one juror looking at that and thinking she wasn't up to her eyebrows in this conspiracy. So that's why I think you'll see a verdict of guilty before the end of tomorrow.
Yeah, correct me if I'm wrong. She did not address the affair with Chad Daybell. She does not address within the affair the strange conversations that were being had. And what Trina K hammered home on is it must have been Ned before we got rid of him. That text message has been read multiple times. So yeah, Judge Mel, you make a good point. There is so much overwhelming evidence that shows at least there were bizarre things being said and concerning things being said about Charles Vallow. And at the time, I mean, let's go to March to July 2019. Taylor Larson, just where Charles' head was at. Did he even know about these girls' weekends and him allegedly being possessed by an evil spirit? I know he had told you, but I mean, this wasn't just a January 2019 thing.
Right. Starting back with our filing for divorce, we did put in there that that she was, he was threatened by her, and that she even told him, if you come home tonight, when he was in Houston, she'd canceled his flight. She said, if you come home tonight, I will, I have an angel here who will kill you and dispose of your body. I mean, we put that in the motion for temporary orders. So knowing that he knew about, and we also put in there about Ned, that he was possessed, and we've seen it, on the body cam footage when he's that night, and that body cam footage of him explaining to the Gilbert PD at his house, that she thinks that he's possessed by Nick or Ned Schneider. That was the night before he came into our office, actually. So the timeline of all that is way back, before March, and then the girls' weekends and all that stuff. I don't think that he knew anything about that. He knew that she was still very active in the Preparing a People organization, and was going to those meetings and with Melanie Gibb. But beyond that, I don't think that he knew that they were doing these castings or anything like that to try to rid his body of Ned or Hiplos.
I would imagine that if he knew those details, the real nitty gritty of it, how concerning that was, that he would probably hide, similar to what Brandon Boudreaux did in Utah when he was worried for his safety. You guys stay on right here, but we've got Lauren Clark with Fox 10 News, who's outside of the courthouse with us as well. So now we have four of you together. Thank you, Lauren, for joining us after your live shot. You were in the courtroom today for closing arguments, so really getting to see Lori up close and how she delivered closings to the jury. But we haven't been able to see the jurors' faces, and you got to see them today and how they reacted.
Do know who's going to be on the jury. The alternates were chosen, and it looks like it's still very predominantly men, although there's going to be 2 women on this jury. But noticing the facial expressions of the jury as they were continuing to listen to this type of arguments. For example, we saw when Trina Kay, the prosecutor, was up out and talking to the jury.
We saw the jurors really lock in to prosecutor Trina Kay's arguments. They were very focused. And I mean, this closing argument went on for over an hour to my notes. And they were still really looking at the PowerPoints that she was putting up and seemed very engaged. I noticed an engagement when Lori was up there, but I did notice a few jurors either looking down to the floor or crossing their arms a bit, and who knows what to make of that. But we did start to see a little bit on their faces as they're going through this evidence, exactly what's going on in their minds, but only time will tell.
Yeah, and I think we were all surprised to see that deliberations ended for the day and they'll be back at it tomorrow. But you think it could be part of that, not wear and tear, but long closing arguments and everything they saw. Quite a day. I mean, were you surprised at that?
I was, but it has been a long day for them because remember, we started off this day asking, is Lori going to take the stand? And it became pretty quick that she was not, and that she was going to rest her case. But jury instructions take a while. It took about 28 minutes to go through those, and the judge read every single line and they were following along with it. Well, at this point, we're now at lunch, and then the closing arguments really consumed the rest of the day. I think it'll probably be good for the jurors to come back tomorrow with a little bit of some sleep and some fresh mind and really start to dig into the evidence and come up with a verdict.
Guys, if you guys have any questions for Lauren, please feel free to ask. But Benjamin, I want to ask you about Trina Kay's presentation. We were just talking about body camera footage of Charles Vallow that the jury has not been able to see. And we know how powerful that is. Over the past 5-6 years, people have always felt that empathy for Charles. Do you feel like that's something that Is there a way to bring it in? I know he's deceased, but do you feel like Trina did enough here to present a pretty strong case through the last couple weeks?
Yes, I mean, we just heard from, Lauren Clark, and Lauren, broke it down for us. The jurors were in tune with the prosecutor. And we talked about this earlier today. It didn't seem like they were in tune with Lori Vallow Daybell. So that's a key indicator right there. Doing trials, I've done murder trials. When the jurors are locked in with you and you're like pretty much talking to the jury, like you have like almost like a one-on-one conversation with the jurors and they're locked in with you, you know that you have a really good case and you're gonna might win this case. When the jurors are having their heads down or are tired or not looking at you, that's when you know it won't be a good day for you. So the fact that did Trina K do enough, the prosecutor in this case, it sounds based upon what Lauren Clark mentioned, being in the courtroom, being able to watch the jurors and their expressions, it sounds like right now she's probably leading and maybe the jurors wanted to go home just to get a good night's sleep and get a good rest and come back tomorrow. But I agree with Mel. I think it's going to be a quick verdict. We're going to have a probably verdict either in the morning or early or late afternoon. I don't think it goes to Wednesday, but Lauren Clark's insight was powerful in the sense that she saw the jurors' faces and that could tell you right then and there what's going to happen in this case.
Jury has definitely had enough of the Doomsday murder case for the day, but Lauren, one more question before you go. Watching Judge Boreski, watching Trina K, we saw multiple objections, almost several sustained as Lori was starting to testify in that closing arguments, as she brought up Tylee and brought up Alex Cox and talking about how can I choose between all of these people that I love. What did you see on their faces? Was there frustration? I mean, we know she's not a real attorney.
Yeah, I think Judge Boreski and Trina K was facing behind me, so I couldn't necessarily see her expressions from that. Judge Boreski has done a really nice job keeping everything in order, which I'm sure is not easy to do when you have a pro se defendant here. I will say it was very shocking for the audience to hear objection after objection after objection all in a row and it being sustained for each and every one, especially at a time with closing arguments, which I'm sure Ben Taylor could kind of go a little bit into. That's typically not something you see, is a lot of objections happening during the closing argument phase there. But it certainly was another continuation of this story with Lori Vallow and how she's getting, these warnings from the judge to not try to testify while using closing arguments or not trying to testify while she's trying to cross-examine the witness. Just another example of her lack of legal expertise in this area.
Lauren Clark for Fox 10 News, thank you so much for being there and giving us your insight from the courtroom. We'll see you soon. Judge Mel, you've been in this position on the bench. Just what is it like trying to stay patient? And do you feel like Judge Boreski has been too patient? How would you deal with the Doomsday Mom?
I think in evaluating the way that it was happened, I do not believe Trina K went too long. When she had the forensic evidence, she had the text messages going back and forth, she had the relationship, she had the demeanor. If you don't address each of those issues in closing argument and show why that proves guilt beyond a reasonable doubt, then jurors, when they get into the deliberation room, may be affected by that omission. So I think Trina was absolutely correct in laying it out. I thought she did a superb job in highlighting some of the testimony in the case. Over my career, I was a prosecutor for 8 years, a judge for 7, a defense attorney for 37 years. I've been seeing literally thousands of cases, and all reinforcing what a horrible decision that Lori made to represent herself, at least an attorney. When you look at her closing argument, she did not address anything that was brought up against her. The religious beliefs, the text messages, the relationship. The only words she said was that she and Vallow were having marital difficulties. I think when a jury gets into a deliberation room and starts discussing that, that stuff is going to hang out like a sore thumb. It was an abysmal presentation, a horrendous decision A first-year law student could have done a better job than she did. At least you'd know where to focus arguments and focus examination. But I think at the end of the day, it reinforced what was going on. And I'm not at all concerned that the jury went home tonight. I think they want to come in tomorrow, be refreshed. They're going to select a foreman. They'll probably take a preliminary count. Hey, where are we on this? What do we need to discuss? But I'll be shocked if by 3:00 tomorrow we don't have a verdict of guilty.
Wow, Judge Mel, Taylor Larson, you got to imagine, what is the jury thinking when they do get back in tomorrow? And are they going to ask each other about the kid, about JJ and Tylee? And at some point, do they find out more when this, when a verdict is in and when it's all said and done? Obviously, we'll know they'll get on their phones and their computers. But this elephant in the room here of what happened in Idaho.
Yeah, I mean, I think even if there were a few that weren't wondering, I think they're probably wondering now, because there was a point in that closing argument, where Lori tried to bring in, why wasn't Tylee in, why isn't those clips coming in? And obviously Trina objected and it was sustained and stricken from the record. But I think that's going to stick out to the jurors who are going to be like, why didn't Tylee come in, and why didn't Lori call her to be a witness then? If she was going to be good for you and you want to point out what she said in your closing argument, why didn't you call her to be a witness? Why didn't you call out any witness? She didn't even present a case at all. So I think that's going to be something that they will probably deliberate about it and wonder until obviously once they're released and they Google it and find out that, Lori's is serving life in prison for, Tylee's death.
Yeah, for her murder. And this may be the most confusing part for the jury, because here she is in closing argument saying that her daughter was protecting her. And then when she speaks about her having the right for self-defense, she says, had. Me and Obi were talking about that earlier, past tense, that Tylee had the right to self-defense. And then if she was trying to protect you and, she's your daughter that loves you, then you do make that point that the jury is wondering why she's not taking that stand, testifying on behalf of her mother against her former stepfather, who came into the house and they had this fight. I think that is going to be talked about, but obviously it really doesn't matter. It's not relevant to the verdict. But boy, when they find out, I mean, Benjamin, I'm sure that's something that you're wondering too, is there's so much that's left open for this jury.
Yes, and jurors are supposed to follow the law and follow the jury instructions. However, they're human beings like everybody else, and they're curious. And a lot of times jurors will kind of assume or make up facts if they can't, understand what actually happened. So they're sitting in court for the past couple of weeks here. They don't see any of her children show up to court. They don't see any of her children support her. They don't see any family members really in court supporting Lori. So the jurors are wondering, where are the kids? Where are the rest of her family members? So jurors are smart, and they'll put two and two together. They're not supposed to Google during the trial. That's an ethics violation if they do that. However, jurors are smart. They're going to kind of put two and two together and kind of wonder what is going on here. And this is going to hurt her. They do count the number of witnesses. They wonder, how did the prosecutor call all these witnesses, and why didn't Lori call one? Why didn't she really put up a defense here? Why didn't she even testify to put on her defense? So jurors, we're going to be talking about that tomorrow when they come back and deliberate. But she has a very uphill battle, and she's just hoping that she got into the minds of one or two jurors that will fight for her tomorrow.
Benjamin, real quick, what does that look like for the jurors when they look at evidence? Is it going to be, a hard drive with the text messages or other things that they were able to see as far as exhibits? How is that going to be laid out for them?
No, that's a great question, Justin. So what they usually do is they go back into a room that's pretty much them. All 12 of them will be in a room. And they usually get evidence from the clerk of the court, who will bring back any evidence that was exhibits, will go back there with them. If there's anything on video, sometimes they'll ask the prosecutor to make sure there's nothing, that wasn't in in evidence that wasn't supposed to be evidence, but they'll scan the disc. They'll go back there with a thumb drive. They'll bring them a laptop. The juror will have a laptop to be able to hit the button and play. Sometimes they'll have a TV to be able to watch any evidence if they need a bigger screen to watch it. So that they have a lot of tools here. And if there's any questions, so that's what we're going to be looking for tomorrow. If the jurors are going through the evidence and they ask a juror question, Judge Boreski will know about it. They'll bring in Lori, they'll bring in Trina K, and they'll discuss it. Whether or not it's a relevant question, then the Judge Boreski will answer it, write a note. If it's not a relevant question, if he can't answer it, he'll say, please refer back to your jury instructions, meaning that he really can't answer the question. And based upon some of the questions, and I'm assuming we're going to get at least maybe one or two questions because there's a multiple amount of evidence, we will kind of see which way they're leaning towards. But yes, the juries will have all the exhibits. Anything that was admitted in evidence, they will have access to be able to watch it on a TV, a computer, or be able to feel and touch it. Of course, they can't open, it's in a Ziploc bag, so they can't open it up and, put their hand down there. But they can actually, look at it, feel it, and actually see the evidence and touch it in the Ziploc bag and evidence bag.
They're going to look at that baseball bat. They may look at the floorboard, things like that. I mean, they could read over the text messages. What would stand out? Mel, you've brought up so much evidence and examples, but take us through the mind of that jury, kind of in that foreperson of how they navigate this. There's just so much.
Well, I think they start at the beginning. We almost start with the marital problems with Charles Vallow and him moving out of state. And then all of the things preceding the offense, the relationship with Chad Daybell, the warning that Vallow sent to Daybell's wife about the affair. Here you've got a brother that's actually coming in and testifying about the concerns and belief he had about the risk to Charles Vallow that was existing, and the fact that she was entertaining these homicidal thoughts. The people in the religious groups that would hear these chilling words. I think all of these things come in. A defense attorney would have at least tried to produce something to explain her indifference. I think her attempt to do it by saying, well, gee, the police officers certainly weren't emotional at the scene. That is about as flimsy as can be. What parent, if their child had witnessed a shooting, wouldn't be distraught with the effect that would have on a child? What person would not provide care? What person goes shopping and doesn't call the police, taking the guy's cell phone? These are the smoking guns, and there's one after the other after the other. And Lori Vallow did not address any of them in a rebuttal, other than Chandler took a long time to arrive at the evidence that they've got. But the bottom line is I can't see any juror hanging up having a reasonable doubt, looking at those messages, looking at her demeanor, looking at the failure to make a 911 call, looking at her indifference in coming back. It shows the real Lori Vallow, not the one standing up and crying a little bit in the opening statement, not doing it in the closing. They're looking at the real Lori Vallow when they look at the text messages and the cold-blooded plans that she made to eliminate her husband.
Okay, so Mel, you think no later than tomorrow afternoon we have a verdict for guilty?
Yes.
All right.
That's a verdict.
Taylor, what do you think?
As far as when we'll have a verdict?
Yes.
Yeah, I think it'll be around the lunch hour. I think they might want to go a little bit longer into the lunch hour, but my prediction would be around noon.
And you believe that she'll be found guilty?
Absolutely, absolutely. And talking about some of that evidence, that they may be reviewing, Lori encouraged them to go and look at her interviews with Chandler PD. And I think that was a huge misstep in her closing argument, because Trina K kind of brought that up in her closing. She said the lack of emotion, you'll see the lack of emotion, the flippant attitude that she had back then, 5 years ago. And so, go look. And then Lori says, go look at my demeanor, basically, in those interviews. I think that's really gonna hit home for the jury. And like Mel said, is a massive smoking gun.
Okay, and Benjamin?
I agree with both Taylor and Mel. I mean, we're gonna have it tomorrow for sure. When we'll have it, I think it depends on how much evidence the jurors want to look through. And let the viewers know, ultimately, the jurors control their own schedule. So if they want to come in and only deliberate for 3 hours tomorrow and say, we're going to go home, they can't. They only want to deliberate all day, they can't. So depending on what the jurors' scheduling like, that's how long I think we'll decide when. If a juror has a dentist appointment, they could call timeout and go to the dentist appointment and then come back. They all have to deliberate at the same time in a criminal case in Arizona. So under the law, they can't have one person not be there and deliberate. All 12 jurors have to be there to deliberate. So they're coming back in the morning. I would think early afternoon. They'll look through all the evidence. It should be done by lunchtime, and we should have a verdict by 1 or 2 o'clock tomorrow.
And you think it will be guilty or not guilty based on the evidence?
Oh, definitely guilty. I agree with Mel and Taylor. I don't see how she overcomes this unless, there's somebody on that juror, one of the 12 people who are just very sympathetic or just very confused about the evidence, maybe just doesn't believe there, because it's doubt. It is the prosecutor's burden. It has to have all 12 people. So if all 12 members don't believe guilty, then we'll have a hung jury, or they'll still continue to deliberate up until Wednesday. But I don't think we'll have that happen unless, like I said, Lauren Clark did some great insight of how the jurors were looking. And it sounds like most of the jurors were in tune with the prosecutor. And that's usually a good sign when they're awake, they're alert, and they're looking at you when they're not looking at the other side of Lori Daybell.
Gentlemen, thank you so much, and we will see you soon, hopefully early tomorrow morning, to just talk some more as we are on Verdict Watch. Thank you for your time.
Absolutely.
Thank you very much.
Thank you.
All right. Obi, they didn't even want the dinner tonight at the courthouse.
No.
They said, we're going home. So here we are waiting for 10:30 tomorrow morning. They will reconvene.
Yeah, a lot of great points from the panel today. But, I think as Benjamin put it, they control their own schedule. And it will be interesting to see how many juror questions there are tomorrow for the court. And maybe that's part of what we're seeing tonight is, as I mentioned earlier, you have now everybody in the same room, everybody talking. First time they've had to deliberate about this case. And I think they probably saw, wow, we all have a lot of questions amongst ourselves, things to talk about. Maybe, maybe it is one person that they feel like they need more time on. But again, they don't want to be there all day. I would think, we'd probably get past the lunch hour depending on questions, but I can't imagine it's going to take them too much longer. And if it does, then you have to wonder if it is 1 or 2 jurors who are still undecided, and that conversation needs to kind of play itself out through most of the day tomorrow. Because I've tried really hard, because of how much we know about the case, it would certainly be impossible for me to be a juror, but in this case, I have often wondered, right, if I didn't know anything about this entire saga, nothing. And I walked into court 2 weeks ago, got hit with all of this testimony, witnesses, that, everything that was presented in court. I would probably have more questions than anybody in that room. And I understand, I'm a journalist. I've been doing this a long time. I'm paid to ask questions, but there's just so much that was left on the table. As you said, elephant in the room. There were many elephants in the room. Think about, we know all the key players in this case are no longer with us, but there are still people involved in this that are. Chad Daybell, right? Where is he? Melanie, like, where is she? Like, Zulema, all the other people that she was on in these, these ladies trips with. I understand that maybe that some of that isn't relevant to the shooting, but the people involved, especially Chad, if I'm a juror, I'm like, where is he? Where are the kids? Like, again, you don't know that the kids aren't alive. You don't know that. Tammy was brought up a little bit, but I just, if you're a juror, and let's say all 12 of them who are going to decide this, all 12 know nothing about the case, I would expect them to have a laundry list of questions now. We heard some of the questions they asked during the trial, but then at the end of the day, once they take all of this in, then they realize Lori's not testifying, not putting up a defense. I fully expect there to be a number of questions, or a number of them that they won't be allowed to answer. The court will not be allowed to answer because the judge will respond with, refer to your jury questionnaire.
So this case is not so simple because there are doors that just can't be opened. And there are a lot of questions that are lingering for the jury, but they have one task: follow these instructions and decide if the state has proven its burden that Lori Vallow Daybell is guilty of conspiracy to commit murder or not. And we'll see what all 12 come to a decision on as jury deliberations continue tomorrow morning at 10:30. We are going to be back here even before that to chat. We'll have our panel on. We got a lot to do still. We got to get our on the record episode ready for tonight. We have a 5 p.m. newscast. We will talk with our anchors and our newscast audience. So head to fox10phoenix.com to stream that at 5 p.m. Mountain Standard Time. But we will be back here tomorrow and updating you all, because we'll basically be playing, closing argument sound bites from today and talking with our panel as we wait for word on my phone via email. We'll all be checking with the court to see if the verdict is in, and then it will be on a 5-minute delay. They will, we all have to follow that order, the 5-minute delay on the verdict being read, but it's not a 30-minute delay, as was everything else, including closing arguments. But we will be back tomorrow morning. You know where to be. Stay here, subscribe, hit the bell, and we'll see you soon.